Good morning. Hold on just a second, let me get you.
Yes, sir.
Okay, you may proceed.
Your Honor, the first case I have is Mario Gary Lopez, 21 CF 680. Your Honor, that's been resolved by plea, if I may approach.
You may. Thank you. Very good. And the defense okay with the score sheet?
We agree with the score sheet.
Okay. Would you go ahead and announce the plea agreement?
Judge, I apologize, could I have it back? Thanks. I didn't know if you preferred me to announce it or not.
Yeah.
Yes, happy to. Your Honor, pursuant to an agreement with the state of Florida v. Mario Gary Lopez, case number 21 CF 680, Mr. Gary Lopez would agree to the entry of a no contest plea to the charge of lesser included offense of aggravated battery with a weapon. He would be adjudicated guilty. He'll be placed on 10 years probation. There will be $25,000 in restitution to the Victim Compensation Fund payable over the term of probation. The court will reserve jurisdiction for 180 days to determine any additional restitution to the victim's family. Next, $967 in court costs, 100 hours of community service, which he may purchase at the statutory rate. He must maintain gainful employment. The plea is a stipulated downward departure agreed to by the state, and the state has no objection to early termination at 7.5 years if there are no violations and all other terms are complete. Those are all of the terms. May I approach?
You may.
That is the state's agreement, Your Honor, and I do have a victim impact statement to read.
Okay. And this, what is the basis for the downward departure?
It's stipulated, Judge. Stipulated factual
So
basis.
Based upon uncoerced plea bargain?
Yes, sir, under the statute.
Sure. I assume that's what it was, but we have to put it on the record. Go ahead, counsel.
Your Honor, Mary Pasco, the mother of the victim, Christopher Pasco, wanted me to speak on her behalf. She did not want to appear today. He is no more in person, but she did want the state to speak for her. Mr. Pasco has unfortunately passed away not from this incident. Your Honor, this case is really a remarkable example of grace and forgiveness. Through all of this, Christopher Pasco believed that the defendant could be helped, and that this case was really from his belief that somebody dropped the ball on the defendant in his service for him to do something like this. Ms. Pasco did want the court to know that when Chris first got home, the family had to deal with him moaning in pain all night long, and his recovery was ongoing and never ending. And that there's not a price that you can put on watching your son struggle and try to learn how to use a wheelchair and learn a new life. But through it all, Mr. Pasco believed the defendant could be helped, and he believed that this was service-based, and that's why he believed that he deserved the probation in this case.
Very good. Mr. Lopez, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Okay, you heard your attorney state the terms of the plea agreement, and I see those same terms are contained in the written plea agreement. Just want to make sure you've, I assume you have, but have you read the plea agreement closely and gone over it in detail with your attorney?
I did, sir.
You understand that by entering into this plea agreement, obviously it's a generous plea agreement, but you are waiving some legal rights in order to get to this point. You're waiving the right to go to a trial to contest these things and some other valuable constitutional rights. You believe that's in your best interest to do that?
I do, sir.
Okay, and you have gone through all the legal consequences of this with your attorney?
Yes, sir.
And you had all your legal questions answered?
Yes,
and you're entering this freely and voluntarily?
Yes, sir.
Okay. Did I understand you correct that this is a downward, not a downward department, this is a lesser included?
It is a lesser included. It originally was a firearm charge. It's now just aggravated battery with a weapon, Your Honor, is the plea.
So the statute that's cited on here is the downward.
It is the downward departure it is the
Is
statute of
the lesser included.
That
Okay,
is accurate.
that's what I wanted to make sure. Okay. Mr. Lopez, based upon, and the state's in agreement with this plea agreement. Mr. Lopez, based upon your testimony and the terms of the plea agreement, the court will accept your plea agreement. There'll be an adjudication of guilt, and you'll be sentenced here today to 10 years probation with $25,000 restitution mandated to the Victim Compensation Fund payable over the term of the probation. Is there any certain amount, that it needs to be paid over? When you have a term like this, like a contract, in theory, you could wait till the day before his last probation in order to pay the.
Judge, I can speak to
Because it's a
that.
substantial.
There's no minimum requirement, but my client has every reason to try and get it done because of the potential early termination prior to, and we do anticipate there is additional restitution to come, Judge. I
Okay.
think we're waiting on that, and that's the reason why the court's been able to reserve. There were some modifications to the home that she's getting quotes to remodify back that weren't completed, is my understanding. Is that accurate?
That's accurate.
Okay. Very good. So, again, 10 years probation with a $25,000 restitution to the Victim Compensation Fund payable over the term of the probation. The court does reserve, which means you'll have a chance to discuss it if you disagree, but the court will reserve jurisdiction for 120 days to determine any additional restitution. 967 in court costs, 100 hours of community service, or you may purchase those community service hours at a statutory rate. You must maintain gainful employment. I assume that would include multiple applications if he's not employed. Plea will be stipulated that this is a downward departure agreed by the state, and the state has no objection to early termination at 7.5 years if there's no violation and other terms are complete. Key terms obviously are going to be that restitution. Okay, any questions?
No, Your Honor.
You do have 30 days to appeal this, even though it's,
Cost of supervision, waived or not?
We'd request it be waived based on the amount of supervision based on the amount of restitution, Judge, if the court.
court
would
will
consider.
waive supervision costs.
Thank you.
Okay, thank you.
Yeah, okay, thank you,
And
Judge.
you need to report immediately to probation.
Thank you. Your Honor, the next case I have on the docket is going to be Gary Lee Dawkins, 24 CF 12. Your Honor, I think we've got a resolution we've reached on that case, but the state's going to have to amend their information. The written plea is already prepared, but can't plead to something that hasn't been charged yet, so that's really going to be a control date. I would expect that to be done much sooner, as soon as the state does that.
That's accurate, Your Honor.
So you want to basically just continue this for,
I'm ready to do it, and I think the state's ready to do it, but on your
I don't know
11/19.
how long is it going to take you to
Not-
do it tomorrow
not-
morning?
Not, I can file the information tomorrow morning, Your Honor. And
You wanna
Then-
do it tomorrow morning? Can't? What do we have tomorrow morning? How many do we have?
But
We have, those are longer hearings, aren't they?
I believe so,
Judge,
Judge.
What's our next standard miscellaneous day?
Not till December 12th, Judge.
You want to do it December 12th?
well, Judge, we really just need to control, the plea is going to be to a misdemeanor, so we're going to
So
do it in
you
writing.
can do a plea in
So we'll just send it to the court. If we just need, whatever date you give me is a control date.
Yeah, let's go ahead and do the December 17th, and it'll just go away.
December 17th?
At least put it on there in case something's
That's fine, Your
not
Honor.
done. We don't want anything to fall through the cracks.
I agree. Thank you, Judge. The
Okay.
next case I have is going to be Tiraporn Dawkins, Tiraporn. That's 24 CF 11. Your Honor, the state's got an announcement, you can announce today?
Yes, Your Honor, the case, the state is entering an old pros in that case.
Very good. Okay, I think that's all you got?
It is,
Fine.
Judge, but I do have one for Ms. Cassie Reed, if I could handle that.
Sure.
Your Honor, there, at least on the docket, there was
Hold
still.
on a second, let me get that one.
Yes, sir. Should be Byler, Byler, 24 CF 1232.
Got it?
Your Honor, I believe a PTI has been entered on that. It was just still on today's docket. Do we have that of record?
Yeah.
Okay, then that can come off and it's been resolved, Judge.
Okay.
Your Honor, that's all I've got for the court.
Very good. Thank you very much.
Thank you. Yes, sir.
So is Brandy back? Ms. Merrifield, you're up. Mr. Shaw is trying to bump ahead of you, but
Morning, Judge. My apologies. I had to meet with an ending.
that's
My
all right.
cases
That's
should
no,
be in
no
the
problem. We understand.
The first one I have is Brent.
Is it under, it's under Flaherty?
It is, Judge.
I
I have Brent
knew that.
Buchter.
Okay.
And Judge, I'll need just a moment so that he can sign. Okay. Just need you to sign that. It's the 14th.
Yeah, I have to be able to go downstairs, so, give me a second. Okay. I'm gonna ask them for a minute to go downstairs.
What are our numbers on December 12th and 17th in the morning?
May I approach, Your Honor?
You may. Thank you. Sure. The defense okay with the score sheet?
We are, Judge.
Would you announce the terms of the agreement?
For Mr. Buchter, this is 23 CF 491. He is going to admit the violation. We're going to modify probation to include Keaton inpatient, bars to bed. That'll be followed by 12 months of drug offender probation, which will have a curfew from 9 p.m. to 7 a.m. and a $100 VOP fee. The curfew may be modified for work and school purposes with permission of probation. It would be an adjudication. He has already been accepted into the Keaton program. And all other terms of probation would remain the same for the balance of what he had left, Judge.
So this is a modification, it's not just
Correct.
It's a change in the term as well.
Exactly, Judge. Everything stays the same with the exception of the Keaton inpatient bars to bed, and he was on drug offender probation previously.
But is this extending or changing
It
the
is
term
not.
of the probation?
It is modifying just to add Keaton, and then the balance, which would have been 12 months,
Okay, that's
remains
what I
the
was
exact
wondering.
same.
Okay, state in
It's a state's
agreement.
agreement, and it represents a legitimate, uncoerced plea bargain.
Very good. So, do you pronounce your name Buchter?
Yes, sir.
Buchter, Mr. Buchter, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes.
So, you heard your attorney state the terms of your plea agreement on this violation of probation, and I see that you've signed the written plea agreement. Have you gone over this in detail with your attorney? Make sure you had all your legal questions answered?
Yes, Your Honor.
Because in order to get to this, you're waiving the right to go to a trial and some other valuable legal rights. You believe that's in your best interest?
Yes, Your Honor.
And you are entering this freely and voluntarily?
Yes.
Okay. Based upon that, the court will accept your plea. There'll be a modification of probation to include Keaton program, which is an inpatient substance abuse program, of course. This is a bars to bed, so go directly there. And following that program, successful completion, I assume it's successful completion of the Keaton program?
Yes, sir, Judge. It's completion of the Keaton bars to bed.
You need to put that in here.
May I approach?
Yep. So, and following the completion of the Keaton program, you'll have 12 months of drug offender probation, which will include specific curfew. And I've got to remind myself what you just announced, 9 to,
I just want to give him the opportunity to see that.
sure? Okay, thank you. So it's followed by, again, the 12-month drug offender probation, And there'll be curfew during that specific probation from 9 PM to 7 AM. And you also have, of course, the always present VOP fees of $100.
Yes, Your Honor.
And your curfew may be modified for work or school, any legitimate, you just have to work with probation on that. Okay.
All right, I'll keep you noted. You ready?
Thank you, good luck.
Thank you, Mr. Becker. Judge, then I have Alexander Edwards in 23 CF 2081. It's a motion to reinstate bond. Mr. Edwards is present. I filed a motion to reinstate bond as to 23 CF 2081. Mr. Edwards posted a $10,000 professional bond on September the 13th, 2023. It was an allegation of felony hit and run. He was put on pretrial services with a GPS, ordered no drugs and alcohol, and submit to random urinalysis, random testing. He didn't have any violations of those special conditions of his pretrial release. There was one alert for a dead battery, which was quickly remedied, confirmed that with his pretrial officer. While he was on bond, he was arrested for a new felony offense on June the 15th of this year. It was fraud by organized communication. He was given a $2,000 cash or professional bond, but his bond was revoked in the 23 case. We are still investigating the fraud case. We do believe that there are some available defenses there, but I need to flush those out. He has been incarcerated for 5 months, and during that time, he did voluntarily enter the Emerald Coast Life Center pod, where he's been receiving substance abuse treatment and counseling, and it's a faith-based program that he's fully embraced, according to Ms. Claw, the director. There is an aftercare program with ECLC that he would have access to if the court were to grant bond. And as the court may recall, this case has taken a little bit of time. It took quite some time for the state to get discovery, to the fact that I had to file a motion to compel just so that the state could receive that discovery from law enforcement. So the delay in this case has been gathering all of the information from this accident. We have scheduled multiple rounds of depositions.
You're talking about the first or second charge?
The 23 case, the hit and run, Judge, the first case. We've had officers that have been unable to show for training. There's multiple FHP. We have another round of depositions on Friday. So the delay in that case has not been caused other than just trying to ascertain all that information. Mr. Edwards does have a stable home environment with his father, who's present in the courtroom today, to support him. And his mother has recently undergone a breast cancer treatment. He'd like the opportunity to visit with her. So we're asking that the court reinstate that $10,000 cash or professional bond, place him back on a GPS with the random breath testing and urinalysis, and also allow him to do that ECLC aftercare program that he can do once he's out in the community.
State?
Your Honor, the state does object to the defendant's bond being unrevoked in 23 CF 2081. Obviously, I don't think I have to overstate that leaving the scene with the death is a very serious allegation. Some 5 months later, he has been arrested for fraud by organized communication, where a victim alleges that the rent money was taken by Mr. Edwards, the down payment for the rent. And what he was on bond when this new law violation was committed. That's the very thing that bond is designed to try to entice someone not to do, is commit new crimes while they're out on bond. The state does object to his bond being reinstated.
Did the state address the assertions that there have been delays in the prosecution of the case because of issues with regards to discovery and access to individuals that they need for the defense?
Well, Your Honor, at this juncture, the state has, and I believe it was prior to Mr. Edwards being rearrested on this 24 CF case, has provided all the discovery to the defense.
Were there delays or
Yeah, there were, Your Honor.
Okay.
Some delay, but it was received prior to him being rearrested. And I do believe that, as far as I can remember, I know we had to set another deposition of one officer. I'm not sure about I'm not sure if there were multiple. I know there was one officer who was unavailable and is supposed to be deposed tomorrow.
Is that the last?
It is not, Judge. The first round of depositions included 5 different deponents. Only 2 were available that showed. So I do the best I can to pare my depositions down. I don't depose everybody that's listed, but the people that are key witnesses in the case are very important. We do have one of those depositions on Friday, and I would anticipate at least another round. We do understand the seriousness of this case, and Mr. Edwards has maintained close contact with my office, and he certainly takes this matter seriously.
I mean, the state placed the original bond on it, so. Court will reinstate, but the condition of pretrial services, a condition of the bond would be that he participate actively in the ECLC aftercare program. And any other requirements that the state would request? Just regular pretrial services, checking in, et cetera?
Yes, Your Honor. The original requirement should be reinstated.
Okay, thank you very much. Give me an order.
And the original requirements, Judge, just to clarify, was GPS with random breath testing and urinalysis.
Correct.
Thank you, Judge. And that
Thank
is
you.
all I have this morning.
Thank you.
You're welcome.
Mr. Shaw.
Good morning, Judge. Tim Shaw. First case I'd like to call is Jaden Keith Bartley. It's under no attorney currently. Last time we were here, he
It's
was
under
arrested.
no attorneys?
It's under no attorney.
Okay.
Bartley, B-A-R-T-L-E-Y. There are 3 case numbers, Judge. They're all VOPs.
I've got them, thank you.
The-
Has he,
We had.
are you attorney of record now?
We are, Judge. We had entered appearances for him when we were here last time. He was picked up on one of the VOP warrants, and so when he
Make
got.
sure the record reflects that they're now attorney of record. I'm sorry, Mr. Shaw, go
Oh,
ahead.
that's fine, Judge. And so apparently when he got rearrested, that took us off all the cases, and so we're having to
Gotcha.
refile. I've spoken with Ms. Sharpless, who is prosecuting these VOPs, and we had asked that it be put on for about a month from now for an actual VOP evidentiary hearing, Judge.
Okay.
There's the companion cases over in the Tallahassee area.
Sure.
So they should be resolved by then.
So we'll continue this till 12/12, is that sufficient time?
Yes, Judge.
December 12th, 9 a.m.
Thank you, Judge, and that's all I had, with the exception of Robert Engelkens, and Mr. Flowers and Mr. Engelkens are here. Come up and hear, please.
Okay.
Good morning.
Good
Your
morning,
Honor.
Mr. Flowers.
Judge, if I could approach, I have an executed written plea agreement, sir.
Yes, sir. Thank you. Would you announce the terms, please?
Judge, if I may, Mike Flowers and Tim Shaw, we represent Robert Engelkens, who is with us today. He is certainly, or currently charged in a 20-count information. He's going to be withdrawing his previously entered plea of not guilty, entering a plea of no contest to counts 1 through 19 of that information. Count 20 pursuant to this agreement is being null pros.
That is correct, Your Honor. The state would announce no cost in California.
Your Honor, the terms of the agreement are spelled out in the plea agreement as follows: that he would be adjudicated to be guilty. He would be sentenced to 48 months in the state of Florida Department of Corrections with credit for time served. That would be followed by 15 years on sex offender probation, and he would be classified as a sex offender, and that's reflected in the plea agreement. Statutory fines and costs, and I think I've listed the accurate number, but
Well, it says monitor required while on probation. You're talking about
an
ankle monitor?
monitor pursuant to Florida statutes. and we
Correct.
discussed
That
that.
is correct.
He, of course, would be adjudicated. Your Honor, there are no other terms. We have checked that the cost of supervision would be waived. He doesn't have the ability, and certainly won't after 48 months, to pay the cost of supervision.
State has no objection to that, of course, discretion.
And Judge, we've discussed this fully with Mr. Engelkens, and he's prepared to answer any questions the court may have with respect to his understanding of the agreement.
Yes, sir. Just point of clarification, as to the 48 months, is that just trying to get it, are that as to each charge, each count, or
No,
just for
What
the
it is,
count
and we-
one,
we
and
can
then
call
they?
that- Yes, sir. And if I can announce that more.
Sure.
More accurately, the 48 months would be for count one, and then the 15 years probation, it would be 5 years on the next three consecutive one to another, and the remaining counts would be 5 years concurrent with the third 5-year period.
Okay.
The total is 15 years, Your Honor.
Okay,
And Your Honor, just to clarify for Madam Clerk, it's going to be on
Mr.
count
Flowers,
one.
go ahead.
Your Honor,
Just
we're recommending on count one.
reflect that in there.
Yes.
Put that, I'm sorry, Ms.
On count one, it'd be 48 months, Department of Corrections, credit for any time served. On counts 2, 3, and 4, each of those counts will be 5 years.
Consecutive.
Sex offender probation, consecutive to each other, and consecutive to count one.
Okay.
Then counts 5 through 19 would be 5 years sex offender probation, concurrent with counts 2, 3, and 4, but consecutive to count one.
Okay.
That makes sense, Madam Clerk?
Got it?
Thank you, Your Honor.
Okay. I'll just let him know. Okay.
And Your Honor, we'll have to get the court's
So,
portion.
actually, I think there's one little, I thought I heard you say 48 months, DOC, 2, 3, and 4 concurrent.
Consecutive.
Well, those three are consecutive, but I thought you said concurrent with the 48 months. I think you meant consecutive to the 48 months, but concurrent, well, consecutive.
I'll just say what I meant.
Okay.
Okay, it's counts 2, 3, and 4 are consecutive to each other and consecutive to count one.
Okay, very good.
Thank you.
And Judge, I think I'm accurately
Okay.
written that, and I understand that.
Sure.
She's important. I believe that is consistent with what the statement I have just announced.
Okay, very good. So, how do you pronounce your last name, sir?
Engelkins.
Engelkins.
Yes, sir.
Mr. Engelkins, would you raise your right hand, sir? Do you swear or affirm that the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
So, Mr. Engelkins, you heard your attorney state the terms of your plea agreement, and those same terms are contained in the written plea agreement, which I see you've signed. Just want to make sure that you have read this closely, yes?
Yes, sir.
And have gone over it in detail with your attorneys.
Yes, sir.
You understand that by entering into this plea agreement here today, you're waiving the right to go to a trial, to force the state to prove their case, some other valuable constitutional rights in order to get this plea agreement. Is that what you want to do?
Yes, sir.
You're doing this freely and voluntarily.
Yes, sir.
Is there a legal basis for this plea agreement?
There is, Your
I
Honor.
mean, a factual basis.
We stipulate that that is in fact the case, Your Honor.
Very good. Okay, Mr. Engelkins, based upon that testimony, the court will accept your plea agreement, and the court on the state is announcing count 20 to be dismissed, null prost. As to counts 1 through 19, the court will sentence you as follows. As to count 1, the defendant is sentenced to 48 months, DOC, followed with credit for time served. Those will be followed by, in counts 2, 3, and 4, consecutive 5-year sex offender probations, okay? So a total of 15 years probation after the DOC sentence. And then you've got counts 5 through 19. Those are all also 5-year sex offender probations, but those will be not consecutive, but they'll be concurrent, so they'll be running at the same time. The bottom line is, the way it all adds up, 48 months, credit for time served, followed by 15 years. That's how it ends up. But it has to be very specific in order to meet the statutory requirements. And there you have the standard probation and fines, 967. There will be a sex offender designation, monitor required, and of course, count 20 is dismissed. And cost of supervision, you requesting that be waived?
Yes, Your Honor.
And that will, cost of supervision will be waived. Okay? Any questions?
No, sir.
Even though you've just been sentenced to this and you've agreed to it, you do have 30 days to appeal it.
Yes, sir.
Okay? Thank you.
All right. Thank you, sir.
Thank you.
That's all we have, Your Honor.
Thank you, sir. Ms. Simon? Is she here?
Your Honor, Ms. Simon went down to injunction court.
Okay, it's all right. And Ms. Dudley is coming. Who came in, Mr. Catalini? I think you're up.
Thank you, Judge.
Sure.
Good morning, sir.
Go ahead and announce, Mr.
Thank you, Judge.
Catalini.
Parker Garea, Randy Catalinic, on behalf of Parker Garea, G-A-R-E-A, case number 20 CF 2010, 20 CF 2356, and 21 CF 2985. Judge, those are all VOPs, and we have an agreement. He would be adjudicated guilty. He will be reinstated to 1-year probation, complete the original terms and conditions, and he may terminate after the completion of all his requirements. May I approach?
You may.
Thank you.
And that is the state's agreement, Your Honor.
Thank you. Thank you. Mr. Gurria, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
So we're reinstating the probation. Okay, you've got it in here, complete the original terms. So when you're talking about completion of all remaining terms, are you referring to like payment of fees and costs? Is that essentially what we're dealing with?
I'm sorry, Your Honor, he's passed term as of June of 2024. So is this going to be a new 1-year term from June of 2024 or from today's date? Because he's been past term for a while now. He's not even been reporting into the probation department since June.
Your Honor, if I may, I believe
Sure.
it's from today's date.
I'm sorry?
It's from today's date.
You want to go ahead and put that in there? Sure.
Yes, sir.
Thank you.
Yes, sir.
So is it formally a reinstatement? Is that the correct language, Mr. Catalani? Is it reinstate? Okay. Modify, reinstate, sometimes those get a little confusing for me. So, did I swear you in, Mr. Gurria?
Yes, sir.
Okay. So you heard your attorney state the terms of the plea agreement. It's pretty straightforward. But in order to enter into this plea agreement, you're waiving the right to go to a VOP hearing, an evidentiary hearing. Have you gone over all this with your attorney? Make sure you had all your legal rights explained to you and how this impacts your legal rights?
Yes, sir.
Okay. You're entering this freely and voluntarily?
Yes, sir.
Okay, based upon that, the court will accept your plea. Was there, is this an adjudication of guilt, or was it previously?
Your Honor, I believe it's an adjudication of guilt. I have a
Okay.
score sheet if I may.
Sure. So there'll be an adjudication of guilt, and the probation will be reinstated 1 year from today's date, and you must complete the original conditions of the probation. If you do complete those, which is mainly the fees and costs, but all the conditions, the probation may be terminated upon completion of these requirements, okay?
Thank you, sir.
Okay, any questions? State's in agreement with this, aren't they?
Yes, Judge.
Okay. And defense is okay with the score sheet?
Yes, sir.
Okay, very good. Any questions?
No, sir.
Okay, thank you. Thank you, Mr. Catalani.
Thank you, Judge. That's all I have.
Yes, sir. A little unclear. I'll give it to you. The 17th has 3. Okay, thank you very much. Mr. Nopes, come on.
Judge, I've got Ladarius Jackson, he's an inmate, and we've got a plea, I just need him to sign it, I've already reviewed it with him.
Okay, very good.
Ladarius, this is exactly what we just talked about, okay? Sign right there for me. May I approach?
You may. Thank you.
Judge, we've got Mr. Ladarius Jackson, 24 CF 2120. The agreement is he's going to enter a no contest plea as charged to count 1 and 2, and he will be adjudicated guilty and sentenced to credit for time served, $615 in court cost, $150 court-appointed legal assistance fee, and we're asking for 12 months in payment, and it won't go to a civil judgment for 12 months.
Very good. Go ahead and put that in there just for, sir, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
Okay, so you heard your attorney state the terms of your plea agreement. Just want to make sure you've gone over it with him and that you're entering this freely and voluntarily.
Yes, sir.
Okay, and you do understand that by entering into this plea agreement, obviously it's a good plea agreement for you, but you are waiving the right to go to a trial to force the state to prove their case. Do you believe this is, doing it this way through this plea is in your best interest?
Yes, sir.
Okay, and you have consulted with your attorney about all this?
Yes, sir.
Okay. Based upon that testimony, the court and the state's in agreement?
Yes, Your Honor, the state is in agreement, and this is not a downward departure. The score sheet will be submitted.
Very good. Based upon that, the court will accept the plea agreement. The defendant will be adjudicated guilty here today, and technically your sentence is credit for time served. So the time you've already spent is your sentence, so you'll be able to be released as far as this charge immediately. You will be required to pay, of course, always the court costs and of $615 and the $150 court-appointed legal assistance fee, but you will have 12 months after you get out today to pay that before it goes to a lien, okay? Any questions?
Yes, sir.
Okay, you do have 30 days to appeal this if you want to, even though it's a good deal. Okay, thank you.
Thank you, Judge.
Thank you, Mr. Noakes. I think that's all you got.
That's all I've got, Judge.
Ms. Simon, you ready? Come on.
I have 2 cases today.
Would your defendant come?
Oh, yeah, come on up here, Mr. Brown. I keep this, I don't give this to the court, right?
Yeah, it needs to go to probation.
Okay. 2 cases, 2024 CF 1558 and 2024 CF 1581. Mr. Brown, present here with me. We have received a referral for pretrial intervention for both cases. I do have the PTI agreement. Mr. Brown has signed that, and obviously he would like to take that.
Okay. Is, Is it a straight PTI deal, or is it a
Yes.
condition of, is
It's
it a hybrid?
It's a straight PTI, Your Honor. Me, and one of these cases is Ms. Basso's, and we're both on board for a PTI.
Okay. So what you need to do is just provide that to the clerk, and you're good.
Okay, I think this goes to the pretrial,
That's what I mean.
the probation officer.
The probation officer.
Yes, Your Honor.
Okay,
Okay. So you've gone over this with your attorney. You understand that by entering this, if you resolve this, it'll resolve your case, but if not, it comes back.
Yes, sir.
You understand that? Okay, very good. Good luck.
thank you, and that's all I have. May
That's
I
all
be
you got.
excused?
Thank you, Ms. Sun. Appreciate it. Okay. So I see on my docket here, there are several individuals here who have been charged with a violation of probation but do not have attorneys. So I'm going to call out your names one at a time. I'm going to ask you to come forward. If you don't have an attorney, you do have the right to have an attorney, because this violation of probation is essentially a new charge. So you have the right to have an attorney. If you do not have an attorney, I'll appoint one for you and enter a denial. We'll come back in December. That'll allow you to meet up with your attorney without giving up any of your rights. This is like an arraignment day, so you'll enter a denial, come back, but have a chance to meet with your attorneys. If you want to hire a private attorney at any time along the way, you can substitute or whatever. But for today, we'll get a plea and we'll go from there. So beginning, Jamari Bush. And this is case number 19 CF 1059. So, Mr. Bush, do you wish to have an attorney appointed?
Yes, sir.
Okay, so the court will appoint the public defender. You do have to fill out the form like you always do to
Yes,
make
sir.
sure you qualify. But we're going to enter a denial on your behalf, and we'll come back on December 12th at 9 a.m., okay?
Thank you.
Okay.
We're providing him my card, and my assistant's name is on it. If he will please make sure he completes the application before he leaves
Okay?
on the first floor, okay?
Yeah.
You bring it to the clerk on the first floor before you leave today.
And then call his office and make an appointment. Okay.
First floor, or out now.
Miss Leslie Early. This is case number 19 CF 2452. So again, Miss Early, do you wish to have the court appoint you a public defender?
Yes, sir.
Okay, court will appoint the public defender. Like I said, we're going to enter a denial on your behalf to preserve your rights, and we're going to ask that you come back on the 12th of December at 9 a.m. for your next court date. Meet up with your attorney, and I think it'll probably be Mr. Medina,
Okay,
that gentleman who's right there.
yes, sir. Thank you.
Yes, ma'am. Justin Hammett, we'll do the inmate later. Justin Hammett. This is case number 23 CF 461. Mr. Hammett, again, you've been, with this violation of probation, you do have the right to have an attorney. You wish me to appoint you an attorney?
Yes, Your Honor.
Okay, so we'll appoint the public defender, again, enter a denial on your behalf. We'll come back on 12/12, December 12th at 9 a.m.
What the recommendation is from the state, just so that we're aware, because I
Sure.
The state's offer is to modify and reinstate with 6 months of community control and then the remainder of probation
Okay.
on standard.
that way Mr. Hammond knows what he's potentially looking at as well.
Okay, very good. And last on this, Daniel Simchak. Did I say that right?
Yes, sir.
Okay, again, you do have the right to an attorney. You wish to have an attorney appointed?
Sir, I met the requirements for the violation, and it was dismissed. I have an order
yeah?
dismissing affidavit.
State?
Your Honor.
This is case number 16 CF 2871.
One moment, Your Honor.
Mr. clerk, if you have, give me any information. I'm sorry?
That's correct, Judge. There was an order dismissing the affidavit filed on 10/28, so the case has been closed.
State?
Yes, Your Honor, the affidavit has been filed, so the state will dismiss the violation of probation.
Very good. Thank you, sir. You're
Thank you.
excused.
Okay.
Okay. Ms. Dudley and Ms. Sandler, if you want to, you've been waiting around a while, if we want to deal with your case, I know it.
Yeah, he went downstairs, I have him come up.
Okay, we got plenty to do.
Yes, sir.
Okay. So, Mr. Harper, you want to,
Yes, Judge, I have a couple.
okay?
They're all in custody, though.
Okay, you want to do the out of custodies? Why don't we do the out of custodies first? Mr. Medina, do you have any out of custodies?
Yes, Judge, I do. They will be very brief, and if I could call first Alberti, Tommy, with an agreement, Your Honor.
Okay.
Tommy Alberti. I'm sorry, I don't have the docket number for Tommy S. Alberti.
There's two cases, 24 CF 1305 and 24 CF 1711.
Yes, Your Honor, and I'm making sure I've made a photocopy, well, a phone copy. May I approach with the agreement that's been signed by all parties, Your Honor?
You may.
It's a reinstatement, so there will not be a need for a score sheet.
Okay? Thank you.
Thank you, Your Honor. Your Honor, under the terms of the agreement, Mr. Alberti will be admitting the violation. He was previously adjudicated guilty. There will be a reinstatement and modification to a new term of 12 months community control. And he knows that's house arrest and that it's very strict. It will be concurrent as to all cases and counts. He was already doing substance abuse classes at Pattison, but the state's recommendation that he's agreeing to would require him to do dual diagnosis, so it's mental health and substance abuse. He's probably going to start over after he talks with Bridgeway and go, after he talks to probation and do it all through Bridgeway for financial reasons, and because they can deal with psychiatrists type stuff maybe a little easier. So it'll be dual diagnosis evaluations within 60 days because he's got to get 2 of them. It's maybe a little more complicated with any recommended treatment to commence within 90 days. 100 VOP fee, 150 public defender fees, Your Honor.
That is the state's agreement, Judge.
Did you get that, Officer King?
Mr. Alberti, would you raise your right hand? I need to swear you in. Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
Okay, Mr. Alberti, you heard your attorney state the terms of your plea agreement. I see those written terms that you've signed.
Yes, sir.
Just want to make sure you understand these terms and you're entering them freely and voluntarily.
Yes, sir.
And you understand you're waiving the right to go to a hearing. This will be a final resolution of this violation of probation.
Yes,
Is that what you want to do here today?
Yes, sir.
And you have had all your legal questions answered by your attorney?
Yes, sir.
Okay. Based upon that testimony, the court will accept your violation of probation, the plea agreement. The court will reinstate and modify to a new term of 12 months community control. Concurrent, all the cases, there's actually 4 separate violations. They'll all run at the same time, so they'll run concurrently. They'll run at the same time. So you got a total of 12 months. But the important thing is to get this evaluation, okay? You're already doing some stuff with it. This is something that'll help you long-term. But you got to pay attention to it. You got to show up. You got to work it, okay? You got 12 months. Don't neglect this. You don't need to be, we got plenty of people in the jail. We don't need another person, okay?
Yes, sir.
So you work this thing, do it right, and you'll get beyond it, okay?
Yes, sir.
Okay. Any questions?
No, sir.
Okay.
Officer King is going to...
No, you don't have to apologize. You're helpful. Go ahead.
State probation, he terms in August of 2026. So do you want him to 12 months CC followed by the remainder on probation? Or
Good
just
question.
term after that 12 months CC?
the agreement was to modify it to 12 months CC running from today. there wasn't any additional supervision in the agreement.
That was my
So it is
understanding.
modifying it, so it's shortening it.
Okay. that's
Okay,
what
no,
I'm
that's a good question, though. Now, you don't hesitate to ask any questions. Those are all good questions. Counsel for the state.
That's exactly what our intention was.
Okay, very good.
Okay?
Okay.
You go talk to her. She'll tell you where to go, and you'll be under her supervision.
Thank you.
Your Honor, next is Justin W. Manos, and I'm mispronouncing it continuously, but it's Manios, 21 CF 777.
How do you pronounce that?
Manus.
Manus.
Manus?
Manus.
Okay.
And I apologize for that. Judge, he made some progress. He works hard, and he paid off $200 for the community service, but he still owes some court costs. He still owes some cost of supervision. I'm asking for an extension with holidays coming up. I'd ideally like to have him come up in January rather than December. If the court will please permit a continuance so he can hopefully pay off his money. Okay.
And the state's request in this would be for the remainder that he owes to go to collections. That's what the state would ask for.
Well,
What we can do, if we just give them a couple months to pay it, maybe it'll go away. What is it? January 21st.
But we will talk to the state about that, whatever progress you can make, and then we'll try to negotiate. What I'm trying to keep is withhold, so if there's a way to send it to collections, it would keep its withhold. I don't want to.
I would keep it.
Okay, so make whatever progress you can till January, then we'll hopefully work it out
So
then.
we're just,
Okay, thank you.
technically, we're continuing until January 21st. The reason, though, is so you can get this thing paid off. Okay?
Okay.
Get it done.
January 21st at 9 a.m.
Our
All right,
first
sir.
25 case.
Okay, thank you. Thank you, Your Honor. Next is Valerie S. Perez. Ms. Perez basically the court deferred sentencing for a Phoenix House decision.
Right.
And this is 21 CF 2912 and 20 CF 1286 and 18 CF 2796. We did get the application in. I checked again with the investigator at the PD's office. And as of an hour ago, she was reaching out again, and we hadn't heard a final decision. Can we get a brief continuance to December and hopefully get it resolved then, Judge?
Sure.
She sent a follow-up, and we're just waiting to hear back.
We'll continue until 12/12, December 12th.
Thank you, Your Honor. Okay? Thank you. 12/12, do you need to write it down, or are you good? Okay, thank you. Thank you, ma'am.
Thank you, Judge.
Thank you.
Thank you, Your Honor. Next is Shana, Shaina Mathis. I'm not sure if she was appointed to the PD, but
Yes.
I think she is.
She is?
Ms. Mathis, her current last name is Daily, like the Daily News.
Okay.
In any event, Your Honor, there's been in essence, some confusion on how much money she owes, so I'm gonna look into that with her. She's gonna meet with me. She had already been in contact with me, very nervous about this, because this is the only time she's ever been in any trouble. And so if we can just deny the VOP.
Okay.
And set it out for a 1 month-ish continuance, that'll give her time to talk to me, and we'll hopefully sort things out, Judge.
So we'll continue it until 12/17, December 17th.
You understand? Okay.
Just
All right.
meet up, stay in good contact with
Okay.
him, and he'll get it
Thank you, Ms.
resolved.
Mathis. Ms. Daly? Yeah, yes, sir.
Your Honor, can I take one out of custody? I gotta
Sure.
go run an errand real quick.
Sure.
Ms. Joppa Leon. It's GIAF.
What is the name?
Jaffa Leon, it's Giaf. First name's Caitlin.
Okay, got it. Thank you.
Yes, Your Honor, may I approach? We have a plea agreement to be filed that does have the PCI paperwork, Your Honor.
Okay.
It's been signed by all parties. I'm going to leave the original copy with Ms. Jaffa Leon so that she can take to probation with her.
Okay. I'm not going to try and pronounce your last name. I'm going to just ask you to raise your right hand. Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
I do.
So I'm looking at the plea and sentencing agreement that you have signed. This is a little bit of a, kind of a hybrid case. You have a pretrial intervention program. You've gone over the requirements, right?
Yes, sir.
If you complete those, your case goes away. But if you don't, you go right, it goes right to sentencing.
Yes, sir.
So you kind of, it's a high risk, high reward. But there's no reason why you can't complete this PTI, the pretrial intervention, those tasks. You just have to stay on top of it, okay?
Yes, sir.
So, any question? The state's obviously in agreement with this?
The state is, Your Honor.
Okay. Any questions, ma'am?
No, sir.
Okay, good luck.
Thank you. Thank you.
Thank you, Your Honor.
Ms. Farkas, you want to do some out of custody?
Yes, Your Honor, I think I only have one out-of-custody client, William Davis. He is present and approaching.
Okay.
Your Honor, this is William Davis. There are two cases on your docket, two VOPs, 2023 CF 155 and 2024 CF 614. I spoke with the state attorney about these cases. We need another continuance. I really need to meet with Mr. Davis to discuss. I have an offer from the state attorney. So if we could have another continuance, I believe that the state attorney is okay with that.
The state has no objection to it.
Court will continue these matters until December 12th at 9 a.m.
Thank you, Your Honor.
Your Honor, there might be a possible warrant that's not been served on him for a misdemeanor. Did you see anything like that?
Nothing popped in my system when I ran it this morning.
Okay, because I looked on the clerk of the court record yesterday, preparing for court, and it said that a habeas was sent out to the sheriff's department, and this has been going on since July, I believe.
Oop, yeah, nothing showed.
So I just wanted, I mean, if there's nothing in there, I don't want to have to arrest him when he comes to my office, because he's my case. I just want to make sure.
No, I show one for a William Charles Davis,
Okay, so not him.
not him.
Perfect. Good, okay.
Okay, we can breathe.
Well, you can do it here in my office.
You want to go, Ms. Dudley?
Yes, sir.
Okay.
Your Honor, I'm sorry, I do have one. Oh, go ahead.
This is going to take some time.
Yes, I have a quick one. It's actually, I believe it's going to be a dismissal. So-
Okay.
Mr. Kane Fuller, he is present and approaching. Sorry about that. This is Xavier Kane Fuller.
Hold on just a second.
It's a good quality.
It's mine, but they.
I believe the state attorney has an announcement in this
It
case.
says it's yours, but yeah. you can-
State,
Your Honor, the state, Taylor Sharpless for the state did receive an email from state probation yesterday that this violation of probation should be withdrawn, and the state is announcing that in court today.
very good. Thank you.
Your Honor.
After we handle this case is going to take just a couple minutes. After we handle this case, we are going to take a short recess of about 10 or 15 minutes. So if anybody needs to use the facilities, you can go ahead and do that. Now would be a good time to do it.
Yeah, this is Cornelius Lee in 21 CF 1406. If I may approach, Your Honor.
May.
Your Honor, the family should be on Zoom for Senator Marcy's call.
Okay. Hold on a second, let me. Forgot they were going to be on Zoom.
Yes, sir.
I'm gonna ask him to take judicial notice of it. I don't have the original judgment, but I'll work on that for this court sheet.
I've got to get my check-in number. I don't have my. Okay, we're gonna have to take a short recess. I gotta go get my dial-in number.
Yes, sir.
So, all rise, please. We'll be, as soon as I can get back and forth to my office, we'll reconvene. We're gonna brief recess.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
got this. Let's roll.
Fight fire with fire, take one.
Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working. Whoa! Not cool, bro.
I'm attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple, to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law.
I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll. Fight fire with fire. Take 1.
Have you been injured in an accident and need righteous representation? Call us, because we fight fire.
Damn thing ain't working. Whoa! Not cool, bro.
I'm Attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple, to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll. Fight fire with fire. Take 1.
Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Fire.
Damn thing ain't working. Whoa! Not cool, bro.
I'm attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to
Do we have anybody in the courtroom that thinks they have a hearing here today? Because we think we've got all the out-of-court folks ready. Or you're just here for somebody else's case? If you are, that's fine, but that's fine. Which case is this? Okay. You may. Sure.
For Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple: to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
Judge, this is Avery Bibbins. Judge, we're resolving both his violation of probation as well as a new law charge that is not on today's docket, 24 CF 2291. He was originally set today for a bond hearing, but in lieu of that, we're resolving all of his cases.
Okay.
Judge. In 24 CF 2291, which is the new law case, it'll be an adjudication of guilt. He'll be placed on 3 years of probation to run concurrent, be assessed $615 in court costs, $150 cost of defense, attend and complete a substance abuse evaluation and any recommended treatment, evaluation within 30 days, treatment within 60 days. In 23 CF 2702, which is the violation of probation, be a modification of supervision to a new term of probation of 3 years to run concurrent. He'll complete the original terms and conditions and assess all applicable court costs. I'm going to have my client sign here. And this is not a downward departure. He does not score. I believe the state will file a score sheet later on today. I think the state
Since we're modifying probation, I don't believe the score sheet's going to be necessary. Correct. The state will be filing a score sheet.
You may. Thank you. So, Mr. Bibbins, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
I do.
So, Mr. Bibbins, you heard your attorney state the terms of the plea agreement?
Yes, Your
And
Honor.
I see that you have signed the written plea agreement that also contains those terms?
Yes, Your Honor.
Have you read this closely and gone over it in detail with your attorney?
Yes, Your
Had
Honor.
all your legal questions answered about this plea agreement?
Yes, Your Honor.
Because you're waiving some valuable legal rights. You're waiving the right to force the state to prove their case and to go to a hearing. You're waiving those rights in order to get a resolution. Just want to make sure you understand what you're doing, and you're doing it freely and voluntarily.
I understand.
Do you have any further questions for your attorney regarding this plea agreement?
No.
Okay. Very good. Based upon that testimony, then the court will accept your plea agreement. In 24 CF 2291, there'll be an adjudication of guilt. And the court will sentence the defendant to 3 years probation, $615 in court costs, $150 cost of defense. You must do a substance abuse evaluation and follow any treatment. The evaluation would be in 30 days. Treatment has to start in 60 in order to get on top of that. In the other case, 23 CF 2702, that's the older case. There'll be a modification of supervision of the probation to a new term of probation of 3 years. These two cases probation will run concurrent. They'll run at the same time. They're not on top of each. It's not 6 years. It's a total of 3 years. Okay? In addition, you must complete all the original terms and conditions on the 2702, the original probation, and the court costs that are contained in there. Okay? Any questions?
No, Your Honor.
Okay. Thank you very much.
Thank you.
Judge, this is Elijah Hendershot before the court on 23 CF 1967. May I have just a moment? Is this still what you're going to do? Sign it, 20 minutes. And you sign down here, and this is about the PSI, which you're agreeing to waive, and the PDR, which you're agreeing to waive. Judge Rudy Harper, on behalf of Mr. Hendershot, he's before the court on 23 CF 1967. At this time, he's going to withdraw his previously entered plea into a plea of no contest. This will be a plea to an adjudication of guilt. Be sentenced to 20 months in the Department of Corrections. Credit for all time served to run concurrent. Will be assessed all applicable court costs to be paid within 18 months of his release. On count 2, which is a misdemeanor, he'll be given credit for all time served to run concurrent. Judge, in that he is a juvenile, he is also signing the addendum, which he is explicitly waiving his right to the PDR and the PSI. Your Honor, if I may approach, this is a downward departure pursuant to negotiated plea agreement. And I believe the state will follow
That is correct, Your Honor. The defendant scores 28 months.
Okay. Very good. You may. Thank you. Okay, Mr. Hendershot, would you raise your right hand, sir? Do you swear or affirm that the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, Your Honor.
So you heard your attorney state the terms of your plea agreement,
Yes, Your Honor.
and I see those same terms are contained in the written plea agreement that you've signed. So have you gone over this plea agreement in detail and read it and gone over it in detail with your attorney?
Yes, sir.
Had all your legal questions answered about this?
Yes, sir.
Because importantly, in order to get to this plea agreement, you're waiving the right to go to a trial.
Yes, sir.
Force the state to prove your case beyond every reasonable way. You're waiving that and say, no, I'd rather take this plea agreement here today. Is that what you want to do here today?
Yes, sir.
And are you entering this plea agreement freely and voluntarily?
Yes, sir.
And nobody threatened or coerced you to get you to enter into it, did they?
No, sir.
Okay. Based upon that testimony, then the court will accept your plea agreement. There'll be an adjudication of guilt on both counts. And the defendant, as to count 1, the felony count, court will sentence the defendant to 20 months Department of Corrections. You will get credit for all time served, and there'll be applicable court costs. All applicable court costs will be paid or must be paid. You'll have 18 months after you're released to pay those before they go to collections, okay? And as to the misdemeanor count, we're basically resolving that today. Technically, your sentence is credit for time served. So that'll be off the books. You'll just be on, serving on the 1 charge. Okay? Any questions?
No, sir.
Okay. You do have 30 days to appeal this, even though you just entered into it. You have 30 days to appeal it. Okay?
Yes, sir.
Thank you. And you said you're going to get me a score sheet, right?
That's correct, Your Honor.
Okay.
Judge, next is Roy Pates, number 24 in the docket. Judge Rudy Harper, on behalf of Mr. Pates, 21 CF 2645. Is this what you want to do? Judge, this is a violation. Judge, we have a plea agreement, and in return for a plea agreement, I believe one of his misdemeanor cases is going to be resolved, and we're going to address that this morning as well. But my client is asking to, prior to sentencing, if he can address the court. I don't know if the court wants to entertain that or not. It would be my legal advice that he not address the court, because I don't know entirely what he's saying. Apparently, he wrote something down, but I would be advising him not to address the court.
Does it affect the plea?
Yes, sir, I don't think so. I mean, I'll probably.
If you want to say something, raise your hand. We got a full day for things. That's not why we're here today, but if you want to say something, raise your right hand.
Yes,
You swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God.
Yes, sir.
If you say something wrong on this thing, the state may withdraw their plea agreement on this thing, but if you want to say something, fire away.
And again, for the record, this is against my advice.
I understand.
I don't know if I should or not. I'm really scared.
Well, then your attorney is recommending you don't. If it's not going to affect your plea, I don't understand unless it'll just make you feel better.
I mean,
At least explain to your attorney what you're going to say, and then he'll tell you whether it's going to be legally detrimental.
that's got it.
Let me just, I don't know exactly what the issue is, but well, hold on a second. Let me explain something. You were here, your attorney was about ready to announce a plea agreement.
Yes, sir.
Okay? I just want you to understand what a plea agreement is about. A plea agreement is a contract between you and the state. Okay? not between you and the state and the judge. I just want you to understand, I haven't seen this plea agreement. I don't have a dog in this thing. If the state agrees with it and you agree with it, about 99.9% chance I'm gonna go along with it, okay? So even if you said something to me that made me think, God, this is wrong, I couldn't do anything about it. So if you're asking me to, if that influences you, I mean, I'm not gonna, if you wanna say something to make yourself feel better, go ahead and say something.
If I said something that would,
You're under oath and it's being recorded.
yes, sir, if I said something here and you said, that can you override this plea or no?
No, I wouldn't.
After
I'm not gonna, I've never overridden a plea.
Right. Okay. Well, you think this?
You know, the reason why I'm not overriding the plea, because I don't know about it. I haven't independently investigated. I haven't heard, you know, the reason why you go to trial is so you get evidence and then I participate, but not now.
I think part of the issue is that there's an offer on the table that is on the table today. And while he's, on the one hand, inclined to take it, he's also has a technical argument that he believes he would like to make that I don't necessarily agree with him on. And so he's at odds. And again, if we can't resolve it today, I don't want him to feel like he's forced into a plea.
Well, not only will, I agree with you, and as a matter of fact, if you do sign it and you present it offer it to the court, I'm gonna enter into it's called a colloquy. I'm gonna ask you, you've been in here before, I'm gonna ask you 6 or 8 questions about, make sure that you're entering it freely and voluntarily. Because that's the one thing I have to do. I have to make sure you're not having your arm twisted, that, you know, they're doing something improper, that you're entering this because you believe it's in your best interest. If you're not, you don't have to enter in it. As a matter of fact, I don't want you to enter in it unless you're very clear, because you're just gonna go back there, and you're gonna end up filing some other paperwork because you don't feel like you've been treated fairly.
The fundamental issue is that if he would like to set this for an evidentiary hearing to make these arguments.
You have a right to do that.
We can do that.
But it's gonna mean that the offer's off the table. I understand you got a decision.
Really to know.
What's that?
I don't really feel like I'm educated in law enough to know.
Well, I
feel
mean,
like I'm probably-
you know, some of these things are a little tricky. You have to rely on, you know, counsel. You gotta, with all due respect to Mr. Harper, he's got a little, well, he doesn't have a lot of gray hair like I do, but he's a very experienced attorney. You gotta rely and, you know, use the best judgment on it. I mean, you know, some of this stuff is a little tricky. That's why you've got an attorney most of the time. Counsel?
Judge, we would ask, if this doesn't get resolved today, that we set it for a BOP hearing so we can get it resolved in another manner other than negotiated pleas.
Sure. Well, that's the alternative. I mean, if we're not gonna plead, we'll go to a trial. You want to take a little more time? Yeah, it won't change anything, but.
Judge, he's before the court on 21 CF 2645. We are also going to resolve 24 CT, which is a misdemeanor criminal traffic case, 24 CT 1837. With respect to the felony violation of probation, be adjudicated guilty, revoke and terminate his supervision, be sentenced to 20 months, Department of Corrections, credit for all time served to run concurrent, assess all applicable court costs would go to judgment. In return for that plea, the state would dismiss 24 CT 1837 and no action on the failure to appear associated with 24 CT 1837. I would submit to the court that addition 24 CT 1837, that resolution is pursuant to my client's request, and the state has agreed to that. I would approach. And the
Is
state-
there a score sheet?
The state is going to file a score sheet later. This is in fact a downward departure. So this is.
What is the guideline sentence?
Guideline sentence is 44.48 months.
44?
44, yes.
So this would be half. More than. And it would address all this credit from this case from 2021, from a correction.
Okay. So each of the VOPs would be 20 months?
Yes, sir.
All served concurrent? Yes, sir, it says concurrent. Okay,
That is the state's agreement.
very good. Mr. Pate, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
Okay, so your attorney has just announced the terms of the plea agreement. Those same terms are contained in the written plea agreement that you've signed. And as we've had this discussion, I know it's a difficult decision for you, but I want to make sure that you understand you don't have to take this plea here today. You have an absolute right to have this a contested hearing and to continue to deny this here today. But your willingness to do that, you would waive, by entering this plea agreement, you would waive the right to go to a trial and have a hearing on it. This will be a final resolution of your case. The state's just told me that the guideline sentence is almost double what they're offering you. So, you understand that?
Yes, sir.
You know what guidelines are, don't you?
Yes, sir.
Yeah. And so, so I just want to make sure, are you entering this freely and voluntarily?
Yes, sir.
Okay. You believe it's in your best, you're not necessarily happy with it, but you believe it's in your best interest?
I guess, yes, sir.
Okay, and did anybody threaten or coerce you to get you to enter into this plea? Did anybody promise you anything other than what's contained in the agreement? Okay. And there is a factual basis for the plea? Is there a stipulation to that? That there's a factual basis to the plea, Mr. Harper?
This is a technical violation, Judge. Yes,
Okay,
sir.
very good. Okay. Anything else you wish to say, Mr. Pate, regarding this? Okay.
No, sir.
Based upon that, the court will accept your plea agreement. There'll be an adjudication of guilt. The court will revoke and terminate all prior supervision, all the prior probation, essentially. And you'll be sentenced to 20 months Department of Corrections for each of the VOPs. You will get credit for all time served, and all these will be served at the same time, concurrently, not on top of each other. And you do have to pay all the applicable court costs and fees. They'll go to judgment. And there's another case, 24 CT 1837. That's a criminal traffic case. The court will dismiss that case, and there'll be no action on any failures to appear associated with that case. Any questions? Even though you just entered into this plea agreement, you do have 30 days to appeal it if you wish to do so, okay? Thank you. You gonna get me a score sheet?
Yes, Judge. And does the defense have an objection to the score sheet that was provided in the discovery?
No, no objection to that.
Okay, thank you.
Judge, this is Nicole Howell. Number 23 on the dockets, before the court on 24 CF 95. This is a violation of probation. If she's not previously entered a denial, she would enter a denial at this time. There is a new law case, 24 CF 2448, and it's actually set all the way out in February. What I'm hoping to do is if we can.
Why is that set out so far?
I'm not certain. It's relatively new. Maybe that's just when it's set. But what I'm asking the court and the
Who
clerk.
set it out there?
I don't think the state or I had any control over that, Judge. I think
As
just
as a
maybe-
matter of course, we don't ever set stuff out that far. We set it purposefully every other, each full cycle.
So her felony plea day is actually set for next week. He already entered a not guilty plea, so it's set because of where her arrest date fell, it gets set out.
It's set out to the next cycle.
Pre-trial, yes, Judge.
Gotcha.
And what we're asking to do, Judge, if we can set this case, this VOP, as well as the new charge in December, to see if we can come to a resolution in December, as opposed to.
Can we do that, Madam Clerk?
Yes, Judge.
Okay. So we'll come back on December, so it'll be December 11th.
Thank you, Judge. I appreciate
So
that.
we'll continue this case till the December 11th as well. We'll track them together.
Yes, sir.
Okay. Thank you, Madam Clerk.
Thank you. And that's all I have today, Judge. Thank you.
Thank you. Mr. Powell, you want to get your case out of the way?
Good morning, Judge.
Good morning.
Judge, I have Ronald Couch on the docket. There's 3 cases.
Okay. Yeah, you just got to figure them out to get them up. Sorry, I threw you a curve there, Steve. You've got 3 cases, but they're all the same. Just you have one defendant.
Correct, yes, sir.
I'll get it to you. Did you see this worksheet? Do you have your objections? Just mark them. I can sign it too, like the initial.
Would you announce the cases, Mr. Powell?
Judge, before the court is Ronald Couch. There's case number 23 CF 392, 23 CF 249, 23 CF 255. Each case, we're before the court on a violation of probation. And Judge, we have a negotiated plea agreement to resolve each of these cases.
Very good.
The state is recommending 180 days county jail with credit for time served. Mr. Couch would enter an admission to the VOP if the court's inclined to impose that sentence.
If that's your agreement,
If I can approach.
if you ask me whether I would go along with y'all's agreement, I have no reason not to.
That is the state's agreement. We
Very
will
good.
provide a score sheet. And does the defense have a objection to the score sheet that was previously provided in discovery?
No, I've reviewed that. It should be 35.4 points with the VOP points added on. I've reviewed that with Mr. Couch, and we have no objection.
Very good.
If I can approach.
You may. Thank you. Thank you. Okay, Mr. Couch, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yeah, I do.
So you heard your attorney state the terms of the plea agreement, and I think that this plea agreement reflects that. And you have signed the plea agreement?
Yes, sir.
So I just want to make sure, have you read this plea agreement? You can put your hand down. Have you read the plea agreement closely, gone over it in detail with your attorney? Make sure you had all your legal questions answered about it.
Yes, sir.
Because it does involve some jail sentence. You understand that?
Yes, sir.
By entering into this plea agreement, importantly, you're waiving the right to go to an evidentiary hearing. You have that absolute right to do that. If you believe it's in your best interest to waive, don't go to a hearing in order to resolve this here today. Waive those rights.
Yes, sir.
And you have gone over all this with your attorney. Make sure you had all your legal questions answered about it.
Yes, sir.
Anybody threaten or coerce you to get you to enter into this plea?
No, sir.
Okay. Based upon that testimony, the court will accept the plea agreement, states in agreement with it. All three cases and all counts will each have 180 days jail time in the Okaloosa County Jail. All probation will be revoked and terminated. You're done with probation. When you get out of jail, you'll be free and clear of these charges. You will get credit for all time served, okay? And the cost will go to collection. If you want to, what we often do, might be better for your client, is give him, say, 180 days to pay the cost, and then they go to collections.
Perfect, thank you.
Okay, why don't you put that on there? So that'll give you a little bit of time, because if it goes right to collections, which is fine, nobody's going to arrest you or anything, but they go after your driver's license.
Yes, sir.
So it'll give you 180 days to pay the collection, pay the fees and costs. If you can do that, it doesn't go to collections, and hopefully you won't get your driver's license dinged.
Thank you, Your Honor.
It's hard to exist around these parts without a driver's license. Any questions?
No, sir.
Okay, thank you.
Thank you.
You do have 30 days to appeal this, even though you just entered into it, okay?
Yes, sir.
Thank you.
Thank you, Judge. That concludes my business this morning.
You have a good day. Thank
See
you.
you this afternoon.
Yes, sir. Okay. Ms. Farkas, you got however you want to do it. You have the bulk of the,
Yes, though that will be dwindling today, so I'm happy to go whenever.
okay, let's go. What do we want? Let's start with,
Starting with Tristan Clark.
yes,
Correct.
start with Tristan Clark.
Tristan Clark, there are two dockets, 2023 CF 2652 and 2024 CF 1422.
Okay.
I'm gonna keep this, I'm gonna sign on the bottom. Yeah, it's an easy oversight.
Tristan Clark.
Your Honor, this is Tristan Clark. The state and the defense have reached an agreement in this case that I have gone over with my client. I'm just going to have him sign it. I can put the date here. Your Honor, may I approach?
Thank you.
I'm also going to provide probation with a copy. Yes. Your Honor, like I said, there are two dockets, 2023 CF 2652 and 2024 CF 1422. There's a previous withhold of adjudication in both counts. Both cases will have the exact same sentence. Admit the VOP, 6 months Okaloosa County Jail, credit for all time served to run concurrent to each other. As a special condition of probation, probation will terminate upon release from OCJ, which will maintain the withholds of adjudication in both counts. $150 public defender fee and 24 months to pay that cost from the date of release.
That is the state's agreement, and does the defense have an objection to the score sheet provided in discovery?
No, there's no objection.
Very good. Mr. Clark, Mr. Clark, would you raise your right hand?
Yes, sir.
Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
Okay. Ms. Farkas, this is a minute detail, but
Yes.
it is important detail. In your plea agreement, you state concurrent on all counts. A count is within a charge, so it's concurrent with all charges.
Yes, I
I
apologize.
assume you want them to be between these two cases,
Yes.
not the counts. Just put cases instead of counts. So you heard your attorney state the terms of your plea agreement, and I just clarified that, for each of the case, there'll be an admission of the VOP, and you'll be sentenced to 6 months in the county jail for each of the two counts, each of the two cases. He made me.
Sorry, Your Honor.
So basically, you have a total of 6 months. They're not stacked on top of each other. They're running at the same time. 6 months, that's the bottom line. 6 months, and then this term in the county jail is actually technically a special condition of the probation, and then probation would terminate as soon as you get released. That allows you to maintain a withhold of adjudication. You've got $150 public defender fees, and you'll have 24 months. That's for each of the two cases. You have 24 months from the date of release to pay it. Okay?
Yes, sir.
Any question?
No, sir.
Okay, good
Thank
luck.
you.
Next is Cole.
Okay. Yes.
You can put them all in.
Just that he's on the list to get transferred. Yeah, you were in a different, we don't have the site. I have it.
Your Honor, if I could speak briefly with Mr. Cole. Your Honor, this is Slater Cole. We have addressed this case a number of times. I think that Assistant State Attorney will have something to put on the record.
I contacted DCF, my contact there, and he confirmed that Mr. Cole is on the list to be transported. He also mentioned there's a possibility to expedite, but I don't believe Mr. Cole meets that criteria to expedite the transport to DCF. There's not a.
But what does that mean? He's on the list to transport.
So they have a whole list that they have to go through. It's like a line to go to the state hospital. They don't have, it's not a temporal, I guess, measure. It's just one after the other. So they said around 6 to 8 weeks. That was 2 weeks ago. So now I'm guessing it's 4 to 6 weeks for him to get transported.
Okay.
Just to put on the
Well, I
record.
appreciate you giving me the information, even though it's not what we want to hear.
I did
It's
get
not
an.
anybody's fault in this court.
No, Your Honor. Correct. I did get an email from an Assistant State Attorney in Crestview that Mr. Cole was the victim in a case at the jail in Crestview. She sent me the offer that she's made to that defendant. Mr. Cole told me today that he would like to drop those charges. He does not wish to cooperate with the state in that case, but I did want to put it on the record. I am concerned for Mr. Cole's safety. He's been at the jail for quite some time and has had a number of issues there, especially given his mental capacity. I know that there's nothing that anyone can do here. I just wanted to put on the record that I do hope we can get him to Chattahoochee as soon as possible. And I know that ASA Sprouse is doing everything he can as well. So.
Okay, so let's do, let's continue this until 12/17, and hopefully we'll have some good news by that time.
Okay, thank you, Judge.
Well, sorry, can't do it faster. We should, but we're doing everybody here is doing the best they can, okay?
I appreciate it. So it should be within 4 to 6 weeks I should go?
Yes, sir. I think that'll be, I think that actually will happen, so good luck.
Do you have any questions?
Alright, thank you. God bless. Jesus loves y'all, man. What would Jesus, God bless y'all, man. Jesus loves you. Yeah, too. God bless you.
Yes, ma'am.
Georgina.
Ms. Jordana's gonna hold the rest of my case.
I'm glad you're the only, I'm not the only one that does that.
It's everyone, don't worry.
Your Honor, she's gonna cover the rest of my case because I'm just rescue, but I do have one with Ms. Graham that might require a little bit of finagling. If we could maybe take that out of ordinance.
No problem.
Thank you. It's Mr. Darius Wilson.
Okay.
I appreciate it, Your Honor. I hate
You,
to
you, want-
make it
you want to do this one and then Darius Wilson, Steve? You want?
What's that?
Is Wilson ready?
I would have to get it.
Well, we can do this, depending, you can bring the other, Wilson up next. Yeah.
Your Honor, this is Armand Culbreth, who also is with ASA Basso. 2024 CF, here, come over here. 2024 CF 2384 and 2023 CF 1247. The state and the defense have reached an agreement in this case. I'm going to have my client sign it right now. Okay, 1114. Your Honor, if I may approach with the agreement?
You may.
Ms. Barnes, you have a score sheet as well? Oh, yes, yes, I do, sorry.
Yeah, I'm sorry.
That's okay.
I'm looking down here.
Yes.
Would you announce the terms of the agreement? And you're okay with the score sheet?
Yes, Your Honor.
Would you announce the terms of the agreement?
Yes, there was a previous adjudication of guilt in 2023 CF 1247 in the 2 counts there. Counts 1 and 2, Mr. Culbreth will admit the VOP in both counts, reinstate and modify probation to add 50 hours of community service, which he'll of course have the entire time of probation to complete, maintain gainful employment or submit 2 applications per week, and that's 50 hours total of community service, not stacked on top of each other. The supervision termination date will remain the same. As always, the $150 public defender fee. 2024 CF 2384, it was a single count, and that count will be dismissed.
Your Honor, that is a state's agreement. We would formally dismiss 24-23-84 based on the totality of circumstances. We believe it's appropriate in Mr. Culbert's case. It was trying to make progress on taking care of the problems.
Point of clarification, counsel. I think I understand what you're
Yes.
what you're wanting to do. So my first question is actually the more difficult. I think the second one I understand. When you're saying you're adding 50 hours of community service, is there other outstanding community service you're adding this to, or is this a total of?
Oh,
Yeah.
sorry, I don't know if you want to.
Your Honor, it is total. It's an additional condition. It's all original terms and conditions.
So there was some community control before?
Community service.
Community service?
No, there was not.
No.
Okay, so this is adding that.
Yes.
And the second thing, if you want it to be one, you've got to, I would just cross out one of them.
Yes, Your Honor.
It's a total of 50 hours of community, not 100, right?
Yes, sir.
I just cancel on one of them. Or put 25 for each, but can't put 50 for each count, and
Okay.
it's 100.
I just crossed it out. That's fine. Trust me.
Okay, that's all right.
Thank you.
Mr. Culberth, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
I do, Your Honor.
So you heard your attorney state the terms of the plea agreement. I see you've signed the written plea agreement. Just want to make sure you understand, you've gone over with your attorney, had all your legal questions answered,
Yes, Your Honor.
and you're waiving the right to go to a trial. You understand that?
Yes.
This will be a final resolution of these violations of probation.
Yes, Your Honor.
And you believe it's in your best interest to enter into this.
Yes, Your Honor.
Based upon that, the court will accept your plea as to both counts 1 and 2 of 23 CF 1247. Will be an admission of the VOP. The court will reinstate a probation for both. And as to count 1, you're going to modify the probation to add 50 hours of community service, maintain gainful employment, or 2 applications a week. And as to count 2, it's reinstate, and the probation, the 50 hours is total, not 50 plus 50. It's 50 total, and the termination date for each of the VOPs will be the same, terminate at the same time. And as a part of the agreement, the other count, the other case, 24 CF 2384, is dismissed.
Yes, Your Honor.
Okay?
Thank you.
Thank you. Good luck.
And I would like to point out that Mr. Colbreth has a number of family members in the audience here who came from Alabama to support him. I'm very grateful.
Thank you for doing that. We appreciate it. Thank you.
I'm gonna meet with probation, okay?
Ms. Graham?
Wilson.
Good morning, Your Honor.
You want to do, after this, you want to do McPherson after this?
Yes, Your Honor, if you'd like.
Hey, Steve? Half? Okay, great. Go ahead with Wilson.
Yes. Good morning, Your Honor. Tricia Graham on behalf of Darius Wilson, who's present before the court. We're here on cases 22 CF 189, 21 CF 2700, 21 CF 1350, 21 CF 1490, 20 CF 2791, 20 CF 999, and 20 CF 998. There is a violation of community control. The third amended one is the most recent one that we have received. We've come to a resolution on all of his cases, Your Honor. If I may approach with a plea agreement, I've met with Mr. Wilson several times. If I just may have him sign this before you. And then today's date will be 11/14/24. And this is everything. Yes.
Just, and that's again.
Same thing, same paper you had before, gotcha. Good. Yep. May I approach, Your Honor, with the,
You may. Thank you. Would you announce the terms, please?
yes, Your Honor. As indicated in the 7 cases listed, the defendant will enter admission or plea of no contest to the violations, and as terms of the plea, it would be in
So I don't
case.
think there's no contest on the violations. I think it'd be an admission.
In 22 CF 89, 21 CF 2700, 21 CF 1350, and 20 CF 2791, 20 CF 999, and 20 CF 998. He will be adjudicated, be sentenced to 5 years Department of Corrections with credit for all time served as to each case. All counts and cases to run concurrently. In case 21 CF 1490, he will be adjudicated 1 year Department of Corrections with credit for time served consecutive to case 22 CF 189. All remaining counts and cases to run concurrently. This plea modifies any prior plea wherein community control or probation is revoked and terminated. There is no suspended sentence that remains. Defendant shall receive full credit from each arrest and booking on all cases. and PSI would be waived.
And Your Honor, just to be clear, they are concurrent but not coterminous.
Okay. Point of clarification on your announcement on 21 CF 1490. State adjudication, guilt, yes, I understand that. 1 year DOC, credit for time served consecutive to 189, and then you say all remaining counts and cases to run concurrently. I'm not clear. I don't understand what that means.
Just the other cases that are listed, Your Honor, before that he's serving the 5-year sentence, so he would run concurrent with that, just for simplification.
I'm not following you.
Okay.
Okay. I hear you, but I don't understand what you're saying.
Shall I list?
So let me ask a question. You announced all these 5 years DOC, all these cases. They're all run concurrently. You get credit for time. I got that. Then you've got 1490, 1 year consecutive to one of the other cases. Okay, so that's consecutive. But I don't understand what all remaining cases, you talking about all the ones you previously announced?
The one in this plea agreement, Your Honor, that he's serving sentences for. So he's on probation or violation of community control for these 7 cases. And so we'd like to resolve and close out all of these cases with essentially the 5 years plus 1 year, so 6 years DOC. But we can't do above the 5 years because it's a 3rd-degree felony.
I understand.
So-
I understand that there's 5 plus 1, but
Right.
I don't understand what the all remainings.
I think the easier way to
Which
say-
ones I want you to
Sure.
name what you're
Okay.
saying to me.
Your Honor, I believe what would have been easier to say is that one case runs consecutive to all the other cases.
The intent would be
Instead
for,
of just that one case is to all of them.
I don't believe that's what we discussed.
It's 6 years total.
Well, I understand 6 years total, but this has to be precise and clear, and I'm not clear about it. So until you make it clear to me, you guys gotta help me out. So what is it? You just said different things. I'm glad I asked the question.
May I have a moment to confer with
Sure.
Ms. Bossow, Your Honor, because thought we had a meeting of the minds on this. Thank you. Your Honor, I think we just said it a little differently, but we did have the same intent. We'd like to cross out
So-
the language that you suggested, which is rightfully so, clarifies if I may.
Sure.
So for the record, I'm just crossing out the language, all remaining counts and cases to run concurrently. So we're keeping in the same, the 21 CF 1490 with the 1 year Department of Corrections with credit for time served, which is gonna be consecutive to that one case, and that's it. I'm not gonna mess with the other cases.
Okay.
Second? I'm just making sure, Mr. Wilson. May I approach, Your Honor?
To a large degree, Mr. Wilson, these are technical arguments that we're discussing. We just have to make sure that it's accurate and precise. What you're getting is 5 years plus 1 with credit for time served as to the different cases. So, but technically, the way it was described, it has to be laid out that way. So you heard your attorney state the terms of your plea agreement. Those terms are contained in the written plea agreement. With that one little point of clarification, I see you sign the written plea agreement. Have you read this closely, gone over it in detail with your attorney?
Yes, sir.
Had all your legal questions answered?
Yes, sir.
You understand that by entering this plea agreement, you're waiving the right to go to a hearing on all these? So it'll be a final adjudication of all of these violations of probation.
Yes, sir.
Is that what you want to do here today?
Yes, sir.
Are you entering these freely and voluntarily after understanding what they are?
Yes, sir.
Okay. Based upon that testimony, then the court will accept your plea agreement. In the following cases, 22 CF 189, 21 CF 2700, 21 CF 1350, 20 CF 2791, 20 CF 999, 20 CF 998. For each of those cases, there'll be an adjudication of guilt, and you're to receive 5 years DOC. You'll get credit for time served on each one of those, and they'll all run concurrently. They'll all run at the same time, okay? As to the remaining case, 21 CF 1490, there's an adjudication of guilt, and the court will sentence you to 1 year in the Department of Corrections with credit for time served, but it'll be consecutive to 22 CF 189. So it's 5 years for all those cases, and then the one case, 1 year, 6, with credit for time served. And in this case, all the previous community control probation is revoked and terminated. That's done. No suspended sentence remains. And again, the defendant will receive full credit from each arrest/booking on all cases. Okay? Any questions? Even though you just entered into this plea agreement, you do have the right 30 days to appeal it. Okay?
Yes, sir.
Any questions?
No, sir.
Judge,
Thank
are
you.
you imposing the VOP fees and the court-assigned fees? for court?
That's right. What about all the fees in this, ladies?
Did not include that. What would be the total standard court cost? It's
So
court
it'd be
appointed.
$100 VOP fee for each, and then the court-assigned fees, which would be $750 total amongst the 7 cases.
So it would be $750 total?
For the court-assigned, yeah, for the court-assigned.
And I did talk to him about the general fees for that, Your Honor, and I'll put that in. So $750 total court cost, which I'll add in there.
Okay.
Okay. So that's the $750 total court costs and fees. Okay.
May I approach again, Your Honor?
You may. Very good. So you got all the standard court costs that were explained to you, okay?
Yes, sir.
Okay. Thank you, sir.
Thank you, Judge Kevin.
You may. Did we get a score sheet?
I handed that to you if you have
Yeah,
another
you
copy
did,
if
you
you
did.
need.
I got it.
Okay.
It is not a charge.
Thank you. McPherson?
Your Honor, good morning. Tricia Graham on behalf of Javante McPherson in case 23 CF 2584. We have come to a plea agreement on this case as well, Your Honor. May I approach with the agreement that has already been signed?
You may. Thank you. Would you announce the terms of the agreement, please?
In case 2023 CF 2584, Javante McPherson will be pleading no contest to the following counts. Count 2, sale or manufacture of a controlled substance. Count 3, possession of a firearm by a felon, constructive. Count 6, possession of a controlled substance, cannabis. Count 8, resisting officer without violence. Counts 2, 3, 6, and 8 would be as charged as stated above. And as part of the plea, the state dismisses counts 1, 4, 5, and 7. Counts 2, 3, and 6, he would be sentenced to 13 months Department of Corrections with credit for time served. Count 8 would be sentenced to time served. All counts to run concurrently with credit for time served, with $615 court costs and fees. He would be adjudicated and PSI would be waived.
What was the last thing?
Pre-sentence investigation would be waived,
Okay.
or pre-sentence report, I'm sorry, how you?
Okay. State?
Your Honor, that's the state's agreement.
Mr. McPherson, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
So you heard your attorney state the terms of your plea agreement. And I see those same terms are contained in the written plea agreement that you've signed. Just want to make sure if you read this closely, gone over it in detail with your attorney.
Yes, sir.
Importantly on this case, this will be a final resolution of your case, all your cases,
Yes, sir.
all your counts. But by doing this, or in order to get it, you got to waive the right to go to a trial. You have a right to go to a trial, force the state to prove their case beyond every reasonable doubt. You're waiving that right to go to a trial in order to get this case settled today. Is that what you want to do?
Yes, sir.
I believe that's in your best interest. And you're doing it after knowledge, freely and voluntarily?
Yes, sir.
Okay, had all your questions have been answered by your attorney?
Yes, sir.
Okay. Based upon that testimony, then the court will accept your plea. The state's in agreement with this?
Yes, this was the state's agreement.
Based upon your testimony, Mr. McPherson, the court will accept your plea agreement as to counts 2, 3, 6, and 8. That'll be as charged. There'll be an adjudication of guilt. And as to counts 2, 3, and 6, the defendant is sentenced to 13 months DOC with credit for time served. Count 8 is a misdemeanor, and the sentence for that is technically credit for time served. That's done. Okay? All these counts are to run concurrently, not stacked on top of one another, run at the same time. So basically, it's a total of 13 months minus the credit for time served. Okay? Is that your understanding?
You said minus credit time?
Minus credit for, it's 13 months, and you get to subtract all your credit for time served. You've got some credit for time served. That'll lessen the 13-month DOC.
Yes, sir.
That's a good thing.
It's a good
for you.
thing, yeah.
Okay,
Yes, sir.
not trying to twist you up here, just trying to explain it. You got your standard court cost and fees that, why don't give him, 12 months or something, 6 months to pay it when he gets out,
Spread that
before it
out.
goes to collections. You gotta pay those things, if not, they'll come after your driver's license.
Now I'm paid it.
Can I do 9 months, Your Honor, or?
That's fine.
Thank you. Is that okay with Ms. Lee?
Yes, that's fine.
And is, I assume, is the defense okay with the score sheet?
Yes, Your Honor.
No downward departure?
No downward departure.
Thank you. And Mr. McPherson, even though you've just entered into this plea agreement, you do have 30 days.
9 months. Sorry, I'm interrupting you, Judge. 9 months to pay court cost fees after release. Okay?
Even though you just entered into this plea agreement and the court just sentenced you, you got 30 days if you want to appeal it. You got to do it within 30 days, okay?
30 days, yes, sir.
Thank you. Okay, thank you. I think you're good, Farkas.
Thank you, Judge.
Thank you. Have a nice day. Okay. Ms. Farkas, you're back up.
Sure am. This is Mr. Dunmore. Hold on, sorry. Okay. This is Malcolm Dunmore, 2022 CF 2556. The state and the defense have reached an agreement in this case, which I have gone over with my client. I am having him sign it now. you. If I may approach, Your Honor.
Thank you.
Your Honor, this is 2022 CF 2556. There is one felony VOP count, a third-degree felony. Mr. Dunmore oh, bless you, will admit the VOP. He'll be sentenced to 9 months Okaloosa County Jail, credit for all time served, revoke and terminate supervision. There was a previous adjudication of guilt in this count, in this case. $150 public defender fee, 24 months to pay from date of release.
Is there a VOP fee?
Yes, Judge.
Oh, I apologize.
Could be
Is that-
$100.
Yeah.
And that is the state's agreement, Judge. Does the defense have an objection to the score sheet provided?
No, there's no objection.
And it's also not a downward departure.
Thank you. Would you please raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
So you heard your attorney state the terms of the plea agreement. Just want to make sure you've, we're going to look at that. Just want to make sure you've read the plea agreement and you're okay with it and you've had all your legal questions answered.
Yes, sir.
You understand that you're waiving the right to go to a trial by entering into this plea agreement here today.
Yes, sir.
You believe this is in your best interest? You're entering this freely and voluntarily?
Yes, sir.
Nobody twisting your arm to get you to enter into this?
Nah, no, sir.
Okay. Very good. Based upon that testimony, then the court will accept your plea. There'll be an admission of the VOP. Court will sentence the defendant 9 months in the credit, 9 months in the county jail. You will get credit for all time served. We're going to revoke and terminate supervision, so no more probation when you get out.
Yes, sir.
You got, of course, to always get the fees and costs. $150 public defender fee, $100 VOP. You got 24 months to pay after you get out before it goes to collections, okay?
Yes, sir.
The score sheet will be provided to the court, Judge.
Thank you. Thank you.
Edwards?
Your Honor, this is Carl Edwards. The state and the defense reached an agreement in this case. I am just looking for it. Sorry. I might need to bring Mr. Edwards back out. I know that I printed up the agreement and have Ms. Bosco sign it. I just can't find it right now. So if we can bring Mr. Edwards back out after I'm able to locate the plea agreement.
We'll find it.
Sorry. Your Honor, this is Ricky Sutton. Excuse me. 2018 CF 1003. This is a VOP. The state and the defense reached an agreement in this case that I've gone over with my client. I'm having him sign it right now. All right. If I may approach Your Honor?
You may. Thank you. Would you announce the terms?
Yes, Your Honor. There was a previous adjudication of guilt in counts 1 and 2 in 2018 CF 1003. Count 1 and 2, it'll be the exact same sentence. Admit the VOP, 28.2 months DOC, credit for all time served to run concurrent. The state stipulates that all time has been served and defendant is eligible for immediate release, meaning he won't need to be transferred to DOC just to be processed and then released. Revoke and terminate supervision, $150 public defender fee, $100 cost of prosecution, and 24 months to pay those costs.
Your Honor, that is the state's agreement. This is not a downward departure, and the state will submit a score sheet.
Does count 2 have separate public defender fee and cost of prosecution?
No, I think we typically just assess it per case, not per
Okay.
count.
Is that right, Madam Clerk?
Yes, Judge.
Mr. Son, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
You heard your attorney state the terms of the plea agreement.
Yes, sir.
I see why you're smiling. You'll be able to get out today. You understand that by entering into this plea agreement here today, you're waiving the right to go to a trial. I
Yes.
believe that's in your best interest.
Yes, sir.
You have had all your legal questions answered by your attorney?
Absolutely, yes, sir.
Okay. Very good. Based upon that, the court will accept your plea. Both counts, you're admitting the VOP in your exact identical sentence, 28.2 months DOC credit for time served. They'll each be served concurrent. They'll serve at the same time. Furthermore, the state stipulates that all time has been served, so your credit for time served is in excess of the 28.2, and the defendant is immediately eligible for release. We're going to revoke and terminate supervision. You're done with that. No more probation, fees and costs. Got 24 months to pay before they go to collections. If not, they'll go after your driver's license.
Yes, sir.
Any questions?
No, sir.
Do we have a score sheet on this?
Your Honor, the state will submit a score sheet. It's not a downward departure.
Okay, thank you. Good luck.
Good luck, Mr. Sutton.
Good luck.
Yes, sir. What's that? 30 days. 30 days to appeal. Your very generous offer.
Oh, I can give you a copy right now if you like. Sorry about that. Forgot. All right. Your Honor, this is Travis Wingo, 2023 CF 943. The state and the defense have reached an agreement in this case. I need to have the state attorney sign it. Let's send it around.
Are you handling all the pretrial detentions, Ms. Sharpless?
Yes, Your Honor.
That's why you're already having lunch. Just so you know, there's no way we're gonna start on time. Because I am gonna have 15 or 20 minutes to do what you're doing.
Sorry, Judge.
I don't mind you doing it.
That's
I don't mind, that's not why I was doing it. I was gonna tell you anyway. I thought you might have, I was gonna tell your compadres to call you and let you know that we're not gonna start on time because
Your Honor, if I may approach,
you may.
I'm making the small edit that I know is coming.
Ms. Farkas has so many plea agreements today that it's slowing everything down. That's good.
She's good at what she do. She's good at what she do.
It's a good resume. You get him resolved, but she's working overtime. She's making everybody else work overtime. Go ahead. Announce the terms.
Yes, Your Honor. You'll see that there's 2023 CF 943. We've also included a criminal traffic case that Mr. Wingo picked up that was the basis for this VOP. That's 2024 CF 1993. So we'll be closing both cases here today. In 2023 CF 943 and 24 CT 1993, the sentence will be the same on all three, in both cases, for all three counts. There were previous adjudications of guilt in the VOPs, and there will be an adjudication of guilt in the criminal traffic case, the new driving while license suspended or revoked. Mr. Wingo will be sentenced to 45 days Okaloosa County Jail, credit for all time served, which will be concurrent on all cases. Court costs, public defender fee, and 24 months to pay from the date of release.
That is the state's agreement, Your Honor.
If I could cross out in the criminal traffic case, I wrote admit VOP, but it's not a VOP.
Yeah, you also need to make sure that it's clear that it's all, when you put all cases, and in this case, there are separate counts. All cases and counts concurrent, to make it clear. So everything's gonna run at the same time.
And Your Honor, there's no score sheet because these are misdemeanors.
I'm sorry?
There's no score sheet because these are misdemeanors.
Thank you. So, Mr. Wingo, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So you heard your attorney state the terms of the plea agreement. I see you've signed the written plea agreement. Have you gone over it in detail with your attorney?
Yes, sir.
Had all your legal questions answered?
No, sir.
No,
yes.
you have had all your legal questions answered?
Yes, sir.
You don't have any more?
No, sir.
Okay.
Don't have any more.
And you understand you're waiving the right to go to a trial. This will be a final resolution of your case.
Yes, sir.
And you're entering this freely and voluntarily?
Yes, sir.
Based upon that, the court will accept your plea. You've got 2 counts that are the VOPs. In both counts, there was a previous adjudication of guilt. You're admitting the VOP, and you're sentenced to 45 days in the county jail for both counts. You will get credit for all time served, and they're concurrent with all counts and cases on both of these. And you've got the public defender fee. Now, on the last one, you only did the public defender fee on one of them. This one, you got both of them. Which one is it?
Well, they go with the cases, not the counts, so.
Okay, you're right. Very good. So. But in 943, is it $150 public defender fee on both these counts, or is it just 150?
No, I apologize. It should just be on the first count, not the second count.
Devil's in the details.
Save you $150.
Trying to save you some money.
Thank you, sir. Thank you.
Okay. So, and likewise, in the 24 CT 1993, the criminal traffic, same thing, adjudication of guilt, 45 days in the county jail. You will get credit for all time served, and again, these are concurrent on all cases and counts, okay? And you've got public defender fee in that one. On all the fees and costs, you've got 24 months to pay from the date of release. Okay?
That sounds good. Thank you.
Thank you very much. Good luck.
Sorry, I just want to clarify, Mr. Wingo would be released today, save for a hold in Walton County. So of
Okay,
course,
so-
that 24
You're
months to
saying the
pay.
45 days have already been met?
Yeah,
but
yes,
there's-
I'm fairly certain
So
that.
you would be able to, you'd be eligible to be released immediately, but for the, you got another case that we're not dealing with. That's
So I
over
just
in
want to make
Walton
sure that
County.
his time to pay will start, of course, whenever he does get released from Walton.
Gotcha.
We have no way of calculating that, so we just add the 24 months plus the 45 days in our system.
Okay, that should be fine. I don't think he'll be there too long. Yes.
Do you need Mr. Edwards back, or do you want me to get your females?
I can do the females. I need a minute for Mr. Edwards. I have to make an edit to the plea agreement, so I can do the female clients if they're up.
Okay, can you call and have him bring the females over?
Whatever is easiest for you. Yes.
Let's,
Mr. Gates is also
let's
ready.
take Mr. Gates, let's do the next males, and we'll hold on the females. Mr. Gates, you've been patient today.
Oh, they've been patient with me, Your Honor. I've had issues outside the courtroom today, so.
Okay. Hope everything's all right.
Yes, Your Honor.
You mean you have a life outside of the courtroom?
I tried to, Your Honor.
Dear.
That's not allowed.
Okay.
Well,
53 now.
yeah, we only have through 59.
Bring who you have, and I will take you. Yeah, this is going to be Mr. Timothy Gardner before the court and 24 CF 1054.
I'm sorry, which one was it?
This is Timothy Gardner. and
Got it,
before the
got
court, 24 CF 1054. He's also on the afternoon docket, Your Honor,
Okay,
unrepresented in 24 CF 2343.
Get appointed to that one if you don't mind.
okay.
Yeah, we're going to, just, it'll be later today.
Are you now attorney of record in the?
No, Your Honor, the court will need to inquire if Mr. Gardner wants to be appointed to that new case.
That's right, this is case number, it's a new case, 24 CF 2343. You do have the right to have an attorney appointed on this new case. You want to have an attorney appointed?
Yes, sir.
Okay, court will appoint the public defender. And
Yes, Your Honor, and I received confirmation this morning that Mr. Gardner had been approved for Keaton. The state is inclined to adopt that as a recommendation for a resolution. If we can bring Mr. Gardner back this afternoon, my anticipation is to write up the plea agreement and
Okay.
get that handled. He's already on the arraignment docket anyway. This just lets us handle it.
There
Very
was no
good.
information filed in that new law case, by the way.
I'll file that
That'll
today.
give us time to file that as well.
thank you. Okay, so we'll come back this afternoon. Can we hold him over, Mr. Stahl? He's got to be held over for this afternoon, if possible.
He's on the arraignment docket too.
Yeah.
Gasper. Your Honor, next is going to be Robert Gaspard. Mr. Gasper's before the court in 3 cases, 24 CF 2463, 24 CF 2464, 24 CF 265. See if I do have an update or a score sheet that I can provide to the court as well. If I may approach for the plea agreement and the score sheet, Your Honor?
You may.
Yeah, continue. It came in yesterday.
Thank you. And defense is okay with the score sheet?
Yes, Your Honor, no objections. Mr. Gaspard does not score more than 44 points.
Very good. Would you announce the terms, please?
Yes, Your Honor. Mr. Gaspard's going to be entering a plea of no contest as charged in all 3 cases. I wrote each sentence for each case, but it's going to be essentially 3 years of probation, each count, each case, all running at the same time. Adjudication of guilt, all counts and cases. And 24 CF 2463, 36 months of probation concurrent with each count and concurrent with 24 CF 2464 and 24 CF 2465. Waive the cost of supervision, $515 in court costs, $150 public defender fee, 100 hours of community service work, anti-theft course, which can be completed online, no trespassing at any ULTA locations, maintain gainful employment, or complete 2 job applications per week. And 24 CF 2464, 3 years of probation concurrent with each count, and with 24 CF 2463 and 24 CF 2465. Again, waive the cost of supervision, $515 in court costs, 100 public defender fee, and then 24 CF 2465, 3 years of probation concurrent with each count, and with 24 CF 2463 and 24 CF 2464, waive the supervision fee, $515 in court costs, 100 public defender fee. Restitution is going to be set at $3,351.94 to Ulta Beauty, located at 34940 Emerald Coast Parkway, Suite 120, Destin, Florida 32541. And so probation is aware Mr. Gaspard's a resident of Louisiana, and he was at the time of the offense.
That is the state's agreement, Your Honor.
Mr. Gaspard, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
So you heard your attorney state the terms of the plea agreement, and I see you, those same terms are contained in the written plea agreement that you've signed. You can put your hand down. I just want to make sure you've read the plea agreement closely.
Yes.
Gone over it in detail with your attorney.
Yes, sir.
You understand that by entering into this plea agreement, you're waiving the right to go to a trial. This will be a final resolution of your case.
Yes, sir.
You believe this is in your best interest?
Yes, sir.
Are you entering this freely and voluntarily?
Yes, sir.
Based upon that testimony, the court will accept your plea. And as to all counts and all three of these cases, the court is sentencing you to identical sentences of 36 months probation. And again, they're all concurrent with each other and with each count and each case. In addition, on 24 CF 2463, there is the 100 hours of community service, anti-theft course, no trespassing at any ULTA location, maintain employment or make applications, 2 applications a week. And there are, for each case, $5.15 in court costs and $100 public defender fee. And there is restitution payable to ULTA Beauty at the address in the agreement in the amount of $3,351.94. Any questions?
No, sir.
Okay.
Can I
You
clarify
do have
something?
30 days to appeal. I'm sorry?
Is count 2, the misdemeanor in 24 CF 2463 also being on probation, or is it 2 times?
that as a felony.
I have all felony. Is that
I
incorrect?
show that it's a first degree misdemeanor.
I take that back, there is a misdemeanor at time served.
Okay.
I'll fix that, Your Honor. When I.
That's all right. It's all right. Appreciate it.
So I think it's actually, is it misdemeanor only that case
That,
or all
just,
three?
it's just that case.
And I think that was my confusion, because it's a felony in the other 2 cases.
Right. So one of your cases is a misdemeanor, and the only difference is your sentence is credit for time served, you're done with that. Okay, no probation, okay?
Yes, sir.
But the same things that I sentenced you to before the other probation, all the same, okay?
Yes, sir.
Okay, thank you. Thank you, Madam Clerk.
Gonzalez.
This is going to Miguel Gonzalez before the court in 20 CF 104. We do have a plea agreement to be filed in Mr. Gonzalez's case, Your Honor. If I may approach. It'll be
Yes, you may.
It'll be a modification, so it's not going to require a score sheet.
Okay, thank you. Would you announce the terms?
Yes, Your Honor. Mr. Gonzalez will be admitting the violation before the court. He was previously adjudicated guilty. We're going to modify and reinstate his probation, waive the supervision fees, $100 cost of prosecution, $150 public defender fee, complete original requirements.
That is the state's agreement, Your Honor.
Mr. Gonzalez, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
You heard your attorney state the terms of the plea agreement. Those terms are contained in the written agreement. Just want to make sure you've gone over it with your attorney in detail.
Yes,
You
sir.
understand that by entering this, you're waiving the right to go to a trial, final resolution of this matter.
Yes, sir.
You believe this is in your best interest?
Yes, sir.
Based upon that testimony, the court will accept your plea agreement. You were previously adjudicated guilty. The court will modify and reinstate probation, waive cost of supervision, and then you got $100 cost of prosecution and public defender fee, and complete all the original requirements, okay?
Yes, sir.
Thank you very much.
Yes, sir.
And this is going to be Mr. Ernest Gaucher before the court in 24 CF 1053. I have a plea agreement to be filed in Mr. Gaucher's case, Your Honor. Let me see if I have an updated score sheet from the state on this one. Does not appear that I do, so we'll have to file it later, Your Honor.
Okay,
If I may approach.
you may. Thank you.
If I remember correctly, I think Mr. Gaucher does score. So this will be a downward departure, Your Honor.
Very good. Would you announce the terms of the plea agreement?
Yes, Your Honor. Mr. Gaucher will be admitting the violation before the court in 24 CF 1053. He's previously adjudicated guilty. We're going to revoke and terminate his probation, sentenced to 9 months in the county jail concurrent with each count and with credit for all time served. $100 cost of prosecution, $150 public defender fee. Mr. Gaucher would ask for 24 months to pay those outstanding fees and any restitution before the sent to collections or civil lien.
That is the state's agreement, Your Honor, and this is a downward departure based on a legitimate and uncoerced plea agreement.
Thank you. Mr. Gaucher, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
You heard your attorney state the terms of your plea agreement. Those terms are also contained in this written plea agreement. I see you've signed it.
Yes, sir.
Have you gone over it with your attorney and understand what this is all about here today?
Yes, sir.
Understand you're waiving the right to go to a trial.
Yes,
It'll be a final resolution of your case here today. You understand that?
Yes, sir.
You believe this resolution is in your best interest?
Yes, sir.
Okay. Based upon that, the court will accept your plea. You were previously adjudicated guilty. The court will revoke and terminate probation. We're done with probation on all these counts. You're sentenced to 9 months in the county jail for each of the counts, and they'll all be served concurrent at the same time. So basically, it's a 9-month sentence. You get credit for all time served as to each count, cost of supervision, cost of prosecution. You'll have 24 months after date of release to pay it. You mentioned restitution in here, Mr. Gates, but I don't see any.
That was set in the original case, Your Honor.
So is there outstanding restitution?
Yes, Your Honor, there was outstanding restitution in the original case that was ordered.
Okay.
We're simply giving him time before the state would send that to a civil lien.
Very good, okay. Any questions about that?
No, sir.
Okay, thank you very much.
Your Honor, this is going to be Mr. Raymond Hutchinson before the court in 24 CF 1132, scheduled as a bond hearing this morning, Your Honor. My anticipation, we're going to go to arguments on this one, Your Honor. Mr. Hutchinson's been in custody since his arrest, which would have been essentially May 15th of this year. The bond that the court set at first appearance obviously is high enough that Mr. Hutchinson can't.
What is it?
It's $10,000 is what it was set as.
Right.
Mr. Hutchinson's asking the court to consider setting that as a signature bond with pretrial services. He'd abide by any conditions the court felt appropriate in this case. I know that there is some concern that of Mr. Hutchinson being homeless or the victim's case being homeless, but he does have an address in Crestview that he will be residing at. He does have one prior failure to appear, but he got confused on his court dates, and I'm not quite sure on whether he was required to plead to that or if it was dismissed, but he wanted to make sure the court was aware that he did have one prior where he was confused about the court dates. He does have significant ties to the community through living here, residing here all of his life, as well as family. You know, in this case, the victim was arrested, pled to felony charges, and has subsequently been arrested again, so he's back in custody. It's been
The victim is?
Yes, Your Honor. It's been difficult to try and locate him to get deposition scheduled. We're trying to get it scheduled so we can work the case moving forward.
You're having trouble getting a hold of him, and he's in custody?
By the time we figured out he was in custody, he had already been released on the time served sentence the state had offered him, and then trying to get him back, we realized he was back in jail on new charges. So by the time we figure out where he's not where he's at anymore. And in this case, Your Honor, I will say I watched the video. I think this is a situation of a self-defense. I know the victim makes a couple different statements about, and I'll quote him, pissing Mr. Hutchinson off enough to incite the incident, as well as some statements about not really wanting to pursue the charges, just wanted to break Mr. Hutchinson's legs. And unfortunately, at this point, he's changed his mind and does want to pursue. But given the issue we've had with trying to track him down, we'd ask the court to consider setting a signature bond for Mr. Hutchinson so that we can work the case and him not pay the price of sitting in custody.
And if the state is not in agreement, is there any other additional conditions that the state would suggest that might offer security, adequate security for the safety of the public that you would request?
Well, Your Honor, if the court does decide to grant a signature bond, the state would ask that Mr. Hutchinson reports to pretrial services weekly and that there's absolutely no contact with the victim, Mr. Jason DeVore. However, the state does object to a reduction of bond. So the current bond, as Mr. Gates stated, is $10,000 cash or professional. This charge is aggravated battery with a deadly weapon, which was a knife. It is a second-degree felony, level 7. Mr. Hutchinson priors include robbery without a weapon, 2 counts of fleeing and eluding, and the most recent fleeing and eluding being in 2023, and grand theft. To address the victim, he is currently in the Okaloosa County Jail. The state has visited him in the jail, and we obtained an address that we will share with the defense in the event that he is out so that depositions can be taken. And the state does have concerns.
Is there a score sheet on this case?
Yes, Your Honor.
What's the?
He does score. I will get you the exact.
49.8 months, Your Honor.
Thank you. And for those reasons, Your Honor, the state is opposed to a reduction in bond.
Anything else?
Yes, Your Honor, I would just add that, if the state is concerned about contact with the victim, I think it's more likely to occur at the county jail, considering he's been in and out, versus allowing Mr. Hutchinson to stay out and abide by pretrial conditions. There will be no additional witnesses. The only 2 witnesses to this incident are going to be Mr. Hutchinson and Mr. DeVore. But looking at the injuries, I think they're more consistent with a fight that potentially required Mr. Hutchinson to defend himself, hence the injury where it occurred on Mr. DeVore. What I did hear from the state was a lack of violent crimes, no prior batteries, no prior batteries of weapons or anything like that. So I think that's something the court could also take in consideration as well.
The court will grant the signature bond with additional pretrial services of a GPS monitor.
Yes, Your
You
Honor.
gotta keep that monitor on or they'll withdraw it. And this will absolutely be no contact. And understand this, it's your obligation to stay away from the victim, not vice versa. So if you see him out in public, he walks up to you, who's in violation? Yeah, even though he walked up to you, you're in violation, so you gotta get away from him. It's your obligation, so stay away from him. If you know where he frequents, don't go around that place. You know a little bit about where, I don't know exactly all the circumstances, but you might have an idea, stay away from it. If it's down in Fort Walton Beach, stay up in Crestview. Just stay away, okay?
And could the court set that at $1 a day for cost? I'll follow up with an order, providing the state agrees to it today, Your Honor.
Okay, thank you.
Your Honor, Mr. Hutchinson's case is going to be scheduled for December, if he signs out, December the 9th now.
Correct. Where, is it December? Is it a December day? Okay, December 9th.
Yes, Your Honor. Your Honor, this is going to be Mr. Phoenix Jordan before the court in 24 CF 1746. He does have a new law violation. It was 24 CF 2418. I entered a not guilty plea on that. That has currently been scheduled for, I think, December the 11th. If we can have this case follow that for December the 11th, and then I will go talk with Mr. Jordan about where we're at.
Very good. So we'll enter a denial and continue the case till December 11th.
You can. Your Honor, this is going to be Mr. Larry Jordan for the court. I have a plea agreement to be filed. He's before the court in 23 CF 2407. Let me grab the score sheet so the court has one. Does not appear that this will be a downward departure for Mr. Jordan, Your Honor, if I may approach.
You may. Thank you. The defense is okay with the score sheet.
No objections, Your Honor.
Could you announce the terms?
Yes, Your Honor. Mr. Jordan will be pleading no contest as charged in 23 CF 2407. It's going to be, or I take that back, pleading to count 1 as charged. Count 2 will be dismissed in exchange for the plea to count 1. Adjudication of guilt placed on 24 months of probation. We're going to waive the cost of supervision, $615 in court costs, $150 public defender fee, 24 hours of community service work, substance abuse evaluation of appointments to be made within 30 days. Any recommended treatment within 60 days of that appointment, random urinalysis, maintain gainful employment or complete 2 job applications per week, and then obviously dismissing count 2. And the state's agreed to take no action on the FTA associated with this case.
That's the state's agreement, Your Honor.
Mr. Jordan, would you please raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So you heard that your attorney state the terms of your plea agreement. I see those terms are in the written agreement that you've signed. Have you read this closely and gone over it in detail with your attorney?
Yes, sir.
Had all your legal questions answered?
Yes, sir.
And you understand that by entering this agreement, you're waiving the right to go to a trial?
Yes, sir.
This will be a final resolution of this VOP. You believe that's in your best interest?
Yes, sir.
Okay. Based upon that, the court will accept your plea. The state has agreed to dismiss count 2, which is possession of a controlled substance, methamphetamine, as a part of the agreement. As to count 1, which is the remaining count, defendant, there'll be an adjudication of guilt. You're sentenced to 24 months probation. Court will waive the cost of supervision, standard court costs and fees. You must do 24 hours community service work, and importantly, within 30 days, do a substance abuse evaluation and follow up with any treatment. Within 60 days, you gotta do random UAs and maintain employment or applications each week. And no action on any FTAs associated with the case. Any questions?
No, sir.
Okay, thank you. Good luck.
Larry.
Edwards.
That's it for now, Your Honor.
I have Carl Edwards back now,
Okay.
and I apologize for that delay. The state and the defense have reached an agreement in this case. I'm just going to have Mr. Edwards sign it. So it's just really talked about 2 years CC with the suspended sentence. Okay? Sign it. And I also have the score sheet that I can provide,
Very good. that
that I will provide.
Defense okay with the score sheet?
Yes, Your Honor. It's 11:14. Okay. If I may approach, Your Honor?
You may. Thank you. Would you announce the terms?
Yes, Your Honor. There is one count in this felony VOP. The case number is 2010 CF 871. There is previous adjudication of guilt in the singular count. Admit the VOP. His current term of probation would have expired already, so I've spoken with probation, and the best way to enunciate that in the plea agreement is to revoke and terminate the current term. He'll be sentenced to a new term of 2 years community control with a GPS monitor. Excuse me, there will be a suspended sentence to the guidelines, 75.825 months. Mr. Edwards will, of course, be required to complete any outstanding original conditions, maintain employment. He's had the same job for quite a while, so just maintain that job. Public defender fee and cost of prosecution.
That is the state's agreement, Your Honor, and this is a downward departure based on a legitimate uncoerced plea agreement.
This is not a down, Oh, well, I guess it is, but this, okay. I'm sorry.
Mr. Edwards, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, Your Honor.
So you heard your attorney, you can put your hand down. You heard your attorney state the terms of your plea agreement, right?
Yes, Your Honor.
And those same terms are contained in the written plea agreement that you've signed. Have you read this closely and gone over it in detail?
Yes, Your Honor.
Questioned by probation or comment?
Yes, sir, I'm sorry.
That's all right.
I misled the public defender. I looked at the wrong term date on here. He actually turns in 2033.
Oh, so we can just,
So we could just modify that.
Okay.
And then 2 years CC followed by the remainder on probation. We would not have to revoke or anything like that. Sorry.
That's okay.
Wrong fault there.
The state's in agreement with that?
Yes, Your Honor.
okay.
So would the original terms and conditions be reimposed?
Yes, so, and that's in the plea agreement already, just contain any outstanding terms.
Okay.
Okay. Why don't we start over? Will you announce the terms?
Yes, Your Honor. So Mr. Edwards will admit the VOP. He is currently on probation, so the probation will be modified to add 2 years of community control, followed by the remainder on the probation that he was on previously. The termination date will remain the same. Complete all original conditions, maintain employment, public defender fee, and cost of prosecution.
Is the suspended sentence, was that previously? Also an, I don't know if it's called a condition or?
Yes, so that is what he scores to on his score sheet, so it wasn't he did not previously have a suspended sentence. Now he has a suspended sentence. That was part of the agreement that Ms. Basso and I reached to allow him to be sentenced to community control instead of DOC time.
Okay. Mr. Edwards, you're still under oath. So you heard the kind of little
Yes, Your Honor.
tweak the agreement just a little bit because you're going to be you're already on probation beyond the 2 years. So the court's modifying your probation to include the next 2 years on community control. That's I like house arrest is a better term for it.
Yes, Your Honor.
So you need a lot of supervision. You got to pay attention to this. Now got a suspended sentence, 75.825 months. And the way it works on this, I think you understand this. You know, you come in there, they slap your hands, you get a pretrial intervention, and maybe you get a probation. Then, you know, you get it up to a little bit, and then it goes to community control. You get a suspended sentence. If you violate again, what's going to happen, Mr. Edwards?
To prison.
You go to prison. Plenty of people, got the dock full of people over in prison. We don't need another person over there.
Yes, Your Honor.
You're like me, you got too much gray hair, you don't need this.
No, sir.
But you're gonna have to pay attention every day. Every day you get up and you need to say, what do I need to do for my probation?
Yes, Your Honor.
It's gotta be task number one. If not, you're gonna go to the big house. You don't need to be going to the big house. Not at your age. Not ever, but particularly not now.
Yes, Your
But you got to do your part, because they're breathing down your throat on this thing. They will ask for prison, promise you. I mean, they're reasonable. They're going to be asking for prison if you violate this again.
Yes, Your Honor.
Okay, you got your chance. You'll be able to get out.
Thank you.
Okay,
Thank you, too.
good luck.
Of course. It's
And
my
you got
pleasure.
30 days to appeal this, even though you just.
No,
Though they're going to meet with you, okay?
This way, sir.
All right. Bye, Mr. Edwards. Good luck.
So we got Rachel, we got your two females, and then we have Mr. Higgs female, and then we'll run through, Mr. Medina's.
Your Honor, this is Kelsey Falk, 2024 CF 2371. Your Honor, the state and the defense have reached an agreement in this case. I'm having Ms. Falk and the state attorney sign it. That's for you too. There you go. You already took care of the misdemeanors. So. Your Honor, the two dockets are 2023 CF 2691 and 2024 CF 2371.
How come only one is on today's docket?
The other one might be on the afternoon docket.
The new one
that was
is-
transferred from Crestview.
That was recently transferred, Your Honor, and that's fairly new, so it's probably
Okay.
didn't get a chance to track.
The 2024 case is a transfer down from Crestview,
Is
so
that
it's possible.
24 CF 2371?
Yes, Your Honor.
Okay. Okay, go ahead.
Your Honor, may I?
You may. Would you announce the terms?
In 2023 CF 2691, count 1 will be dismissed. Count 2 will be an adjudication of guilt, 24 months probation, which will be concurrent to the other term of probation. Enter and complete the Phoenix House inpatient treatment program as a term of that probation. Waive the cost of supervision during treatment, court costs, and public defender fee. 2024 CF 2371 is just a single count. Ms. Falk will be adjudicated guilty to the lesser included offense of felony battery. It was originally charged as aggravated battery on a pregnant person, a second-degree felony, so she'll be adjudicated guilty to the lesser included offense. The statute is there, 784.03. Same thing, 24 months probation with a term of completing Phoenix House, waiving the cost of supervision during treatment, court costs, and public defender fee.
That is the state's agreement, Your Honor, and the state will submit a score sheet. This is not a downward departure.
Ms. Falk, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes.
So you heard your attorney state the terms of the plea agreement, and those same terms are contained in the written plea agreement that you've signed. You understand that by entering into this agreement here today, you're waiving the right to go to a trial.
Yes.
And this will be a final adjudication of your cases. Do you understand that?
Yes.
You're entering this freely and voluntarily?
Yes.
Okay. Court will accept this as obviously a good deal. You got two big charges that are being knocked down.
Yes, sir.
Better pay attention to this probation. They may not be quite as friendly next time around.
Yes.
Court will accept the plea on 2691. The court will dismiss count 1. And as to both of the other two charges, count 2 and 2691 and 24 CF 2371, there'll be an adjudication of guilt in both cases. And in 2371, it's to the lesser included felony battery, but the sentence will be the same, 24 months probation. And as a condition of that probation, you must enter and complete Phoenix House inpatient substance abuse program. That'll be during the term, and then you'll complete the terms of the probation. I don't understand the way you've got it worded. Say 24 months probation, enter and complete Phoenix House treatment as a term of probation. I don't know what that is.
Yes, that just means that probation will start running, and it will run while she's in treatment, as opposed to like completing treatment and then starting 24 months probation.
Okay, got it.
As,
No, that's all right. Thank you.
sorry.
Okay.
you go.
Okay, so, but it's important. Phoenix program, that's great, hey, we can get out and go do that. Gonna take some serious thing, you have to buckle up on that. You know, every day you get up, there gonna be some days you're gonna get up and you're gonna wanna run. You run, you're gonna be back here, back with an orange suit. Don't do that. I want you to be successful, we really want you, but it's gotta start here. It's not somebody's gonna do something for you. That's not the way substance abuse treatment works. It's got to start inside here. Then maybe somebody can help, okay? You got a chance, take advantage of it, okay? Good luck. I'm sorry? Yes, this is bars to bed, right?
Yes, it is bars to bed.
30 days to appeal your.
Yes, you do have 30 days to appeal it, bars to bed.
Yep.
Yeah, go ahead and give it to me.
Thanks. Your Honor, this is Dana Skip, 2019 CF 1850. This is a VOP. The state and the defense have reached an agreement in this case, and I've gone over it with Ms. Skip already. I'm just having her sign it.
Okay.
Credit for time served. You're about to terminate your selections. Yeah, 11:14. There you go. Your Honor, if I may approach.
You may. Thank you.
Your Honor, there's a previous adjudication of guilt in all charges here. And I'm sorry, I didn't read the other case is 2021 CF 830. Ms. Skip will admit the VOP in all 3 counts. She'll be sentenced to credit for time served. Will revoke and terminate supervision, and all outstanding monetary obligations will go straight to collections as she's completed all the other terms.
Okay, pretty straightforward, Ms. Skip.
Yes, sir.
Raise your right hand. Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
So you understand this will be a final resolution of your case and revoke and terminate supervision. Just want to make sure you've gone over it in detail with your attorney.
Yes, sir.
Okay. Based upon that testimony, the court will accept your plea. There's an admission of the VOPs on all 3 counts. Your sentence technically is credit for time served. Court will revoke and terminate supervision, that's probation. All outstanding monetary obligations go to collections.
Thank you.
Any questions?
No, sir.
Thank you. Mr. Gates. Amber Hawkins?
Yes, sir. Ms. Hawkins? This is going to be Ms. Hawkins before the court in 20 CF 1, let's make sure I get it right, 24.
2455 and 20 CF 3028.
Yes, Your Honor, we have a plea agreement to be filed in Ms. Hawkins' case, if I may approach, Your Honor.
You may.
The state will be filing this court sheet later.
Thank you. Could you announce the terms?
Yes, sir. Ms. Hawkins will be admitting the violation before the court in both cases in each count. She was previously adjudicated guilty. We're going to revoke and terminate her probation. She'll be sentenced to time served. $100 cost of prosecution, $150 defender fee. She'd asked for 24 months to pay those from her date of release before they're sent to collections. And 24 CF 3028, again, revoke and terminate probation, credit for time served, $100 cost of prosecution, $100 public defender fee, again, 24 months to pay those outstanding fees before they're sent to collections.
That is the state's agreement, Your Honor, and this is not a downward departure.
Very good. Ma'am, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
You heard your attorney state the terms of the plea agreement. Those are in the same written agreements that, the written plea agreement that you've signed.
Yes, sir.
Just want to make sure you've gone over it with your attorney, understand all the legal ins and outs of this.
Yes, sir.
Obviously, it's a very good deal. We're revoking and terminating probation, credit for all time served. So you're basically finished with your probation. You do have these costs and fees. You'll have 24 months from the date of release to pay them, and any restitution before they're sent to collections. Any questions? Okay, good luck, man.
Thank you so much.
Your Honor, may I approach with an order on Mr. Hutchinson's case?
You may.
Creighton Anderson. Steve, reviewed it and no objection.
Okay, thank you.
Creighton Anderson?
What's today's date?
November 14th, Your Honor.
Your Honor, Steve Medina with Creighton Anderson. I think he was on the afternoon docket with a new law charge. And basically, he can waive arraignment and not have to appear at 1:30.
Is that, hold on, information is filed?
Yes.
Okay, information has been filed. And I think I have to, unless you made an appearance previously, oh, that's the wrong one, Creighton. So you're entering a not guilty? and
Yes, Judge,
this
if we can
afternoon?
if he can enter a not guilty in 24 CF 2372, he has a substantial DOC offer, and I'm going to pursue depositions in the new law. He'd already done a denial in 23 CF 2828, the VOP case, and I'll come see him, and also he's going to be applying for inpatient drug treatment, Your Honor.
So on the new case, when are we?
It looks like we're already
December
on the,
9th.
The 11th if he's in custody, Judge.
December 11th. So we'll track both of them to December 11th.
yes, Judge,
Okay.
thank you.
Very good.
Okay?
Yes, sir.
Thank you.
I'll see you before then.
All right, that sounds good.
Xavier Banks. Your Honor, I'm sorry, I just needed to make a note for Mr. Anderson. One moment, please. Otherwise, I'll forget. Your Honor, Steve Medina with Xavier J. Banks. My understanding is the Public Defender's Office, which is me, I did a motion to withdraw for Mr. Banks because of a conflict of interest, so he'll be getting RCC. I'm not sure what the status is of the order on the motion to withdraw that was dated November 12th.
I mean, it doesn't matter.
So at this point in time, Your Honor, he would deny the VOP, and
We'll deny it and continue until the next month, which will be 12/12.
and I
Okay?
anticipate he'll be getting RCC to come see him soon.
Very good.
Thank
Okay,
you.
thank you.
Lee Brooks. Your Honor, Steve Medina with B. Alvin Brooks. Mr. Brooks's cases are, case is 22 CF 1635. Mr. Brooks wants to do Phoenix House. The state is not willing to accept a Phoenix House deal. He had graduated from Keaton and then picked up a misdemeanor case, and we've denied the VOP. The state won't agree to a Phoenix House deal. The state is willing to do a plea to the bench agreement with a 60-month cap on DOC, and advises that his guideline score, which is otherwise the offer, is 52.8 months. Mr. Brooks, at least at this time, is not ready to accept a plea to the bench agreement with a 60-month cap on DOC. And it's my understanding from talking to Ms. Sharpless that in light of the state's unwillingness to do Phoenix House, that she's going to notice it for a VOP evidentiary hearing with subpoenas. So I'm certainly not here to make him take a deal, pressure him, but it's basically a plea to the bench agreement or VOP evidentiary.
So we're going to continue the matter. for today, we'll continue till 12:12, and you guys, you need to schedule a hearing, schedule it up.
Okay,
Yes, Your Honor.
thank you. So if it's gonna be scheduled for a VOP evidentiary, I
It's not
think,
being scheduled for a VOP because that's an afternoon hearing. It's got to be coordinated with my judicial assistant. Right now, we're just continuing it on the regular miscellaneous docket till 12:12. If you all choose to go the evidentiary route, then you got to coordinate with my judicial assistant.
I'm just advising, Your Honor, that I'm not asking for it, but if
I
the state,
understand
if
that.
the state's seeking it, that
I'm
it
just
should go
saying,
ahead and
if-
do that.
However it comes
Yes.
about,
Yes,
if you have an evidentiary hearing, it's got to be coordinated with my judicial assistant.
well, understood, Your Honor, of course. Thank you, Your Honor.
Thank you.
Your Honor, that concludes, I believe, the morning docket. Did you want to go?
The only, I've got a Haley Barnard.
Okay.
And there's Sean Goodwin,
Sean Goodwin, and you said Haley Bernard?
Yes.
Yeah, that's exactly right. Thank you.
Haley Bernard is out in custody. She's not in custody, she's not.
Yeah, and I've got her as out of custody, but I don't know, but
Yes,
she's not here.
Your Honor,
I may be mistaken, but I don't think she's here.
she's my client, 22 CF 2083. I did ask my office to reach out to remind her that she has court. The last time she was in court, she was pregnant, and that's been so the pregnancy's been going on for a few court appearances, Your
Yeah,
Honor.
the pregnancy doesn't keep you from picking up the phone and talking to your attorney. With all due respect, I'm sorry.
Well, I'm not saying that it
I
does.
know.
I am advising the court is that we called the number we had, and that
What-
she's not present.
What's the state?
State's gonna ask for a capias.
Hate to have a capias on a pregnant woman, but
I
I'm
do
going to issue a no bond capias.
But she needs to meet with the attorney so we can get this resolved.
It's been a long issue of her.
That's all right. No, you don't have to you don't have to give any explanation. She's not
Okay.
here. She gets the capias. You,
Thank you, Your Honor.
Sean Goodwin?
okay, Mr. Goodwin? So, Mr. Goodwin, hold on a second. So you've been charged with a violation of probation.
Yes, sir,
At this
I have.
point, you don't have an attorney. The court will grant you, if you wish to have an attorney appointed, I can deny it, and then you can come back. Is that what you want to do? You want
No,
an
I'd like to
attorney?
have one appointed, sir,
Okay,
please.
so we're going to appoint the public defender. We're going to continue to enter a denial. That'll preserve your legal rights. We'll continue this until 12/12.
Is there any, can I speak, sir? I'm sorry.
I'm sorry?
Can I speak? Can I say something?
Sure.
My mother is 75 years old, sir. She doesn't have anyone to care for her. Is there any way I could know what the state would be
Well,
offering
it'd
today?
be good if, if you want to care for your mother, stop violating probation.
Yes, sir.
I hear this all the time.
Yes, sir, I
Somebody's got to
understand.
cover, and it's like, well, okay, then don't get arrested.
Yes, sir.
I'm sorry.
Yes.
It's been a long morning for me, too.
Yes, sir.
Your Honor, did I ask what the offer is for?
Yeah, that's a good question.
The state's offer is to modify and reinstate with 6 months of community control.
Who are we appointing?
Mr. Gates.
Okay, we're going to hold you over till this afternoon. Might be able to make a deal so you can get out and be with your mama.
Thank you, Judge Ketchum.
No,
Thank
you don't
you,
have
sir.
to thank me. It's thank the state.
Thank you. Thank you very much.
Yes, we're going to take a break. I know we've got 12:30, we're running a full hour late, but we'll come back and do pre-trials at 1:30, trying. Now, we've got 3 pre-trials. How do we anticipate, one of them's going to be a full-blown hearing, right?
Yes, one of them will be a full-blown hearing.
Which one is that? Yours? We got
Mr.
2. Which one?
Camarda.
He's my client, Your Honor.
Okay.
And Your Honor, Howard would be a request for a continuance.
And, Your Honor, I believe that there's going to be a stipulation on Mr.
Steve.
Bessinger, I'm sorry.
What do you mean a
I'm forgetting
stipulation of?
The defendant is not going to oppose the entry of the requested pretrial detention order,
Okay.
but we'll have to have him out here to discuss it.
Yeah, let's let's go ahead and take a break. We'll come back at 1:30. Hopefully we'll, how long do you anticipate Camarda?
Your Honor, there'll be 2 witnesses. I don't think it will take us very long. Maybe 20 minutes, maybe 20, maybe 30 minutes, maybe.
Yeah, I don't.
The one thing we could do, if you all, but I'm not gonna do it unless you all think it'd be more convenient. We're coming back at 1:30 is the schedule for all the felony pleas. Maybe we should do those first and then do the pretrial actual hearing after that. So we don't have a courtroom full of people. I mean, I don't mind doing it, but it's inconveniencing all the people we've got. I don't know how many.
I know I do have an officer who has something tonight, but I'm not sure exactly which time he needs to be out of here, so I will, if I can just have 1 minute, I think they're
Well,
outside, so,
Well, let's just break until 1:30 and then you can let me know then.
yes, okay.
Okay.
All rise, please.